But though today is not mentioning them, and under compelling circumstances, I am mentioning one matter. That mentioned matter will be taken up today at 4 p.m. My urgency is tomorrow the position will be taken up by the
Which item?
1344.
1344. All right. Please come at 4 p.m. Yes.
And may I
4
permit to
p.m.
mention item number 379 of monthly combined list is suit against Asansol Municipal Corporation.
Yes.
So, my lord, there the petitioner made an application under 151 for a temporary water connection. That has been denied by the trial court. He is living without water connection. That is the
679 was not mentioned. You have not mentioned it earlier.
earlier mentioned.
Yes. Come tomorrow. Yes. Call the list.
Item number 1, that I am for the respondent, TPC authority. But in spite of your lordship's order, the matter was not transferred because this principal bench is saying no technical problem is there, so you clear the technical problem. But I think your lordship exercise the power under Article 227 and direct the transfer of the matter from Asansol to the principal bench.
For the petition.
Yes.
Your lordship
That would be much better. I
No. What was better, your lordship, have a look at your lordship's last order of
Yes.
9 July.
think.
But kindly have a look at what we have done pursuant to your lordship's order. I have given a chronology of events.
Yes, I have.
So many times we have mentioned the matter. But there is what is appearing, my lord, there is a technical glitch. Lordship will see is continuously from serial number 3. That is
Yes.
the date when I have affirmed my transfer application. Then
Yes.
with serial number 4, I tried to upload it in the portal. There is an error which I have annexed at page 11. This is what is showing in the
Page 11.
Yes, page 11. Your lordship will see. This is the portal
Top right corner.
error. Kindly see top right corner.
Error by fetching case details.
So this was continuously coming, my lord. Then, my lord, we wrote to the help desk also, June 30, serial number 5. Then, my lord, we mentioned on July 1 before.
What did the president say?
President is saying, my lord, we cannot waive it. It has to be done through the portal. Then, my lord, both of us went even to the help desk, my lord, the portal there. They said, my lord, it is a technical glitch and we do not know what will be the time.
Article 227 just say order pass করুক না.
Yes, my lord, that is
All right.
Power, your lordship kindly.
Yes. Mr. Shen, I am keeping it day after tomorrow.
we shall argue the matter. Is a very short point, my lord.
Day after tomorrow.
Whether-
Date mention করে রেখে দাও।
Obliged, my lord. Execute
ফাইলটা তো আমায় পাঠিয়ে দাও। Same ID.
an
Same
application was filed by the decree holder before the executing court in respect of a notice of disconnection which is outside the scope of that decree.
No, your
And
lord.
it's been stayed by a blanket order.
Mr. Shen, this is the difficulty nowadays. Everything has to be routed through the portal, and
This is the
if it is not,
That is the real difficulty.
that's the
But your lordship
Acha.
can direct the matter to be transferred.
yes. Let me.
Why your lordship will exercise jurisdiction? I can't move
এটাই তো
from
বলছি।
আসুন। Yes.
Item number 2.
Who is that matter? I'm keeping it day after tomorrow because you have made your submissions.
Yes, my lord, was on
But
the earlier occasion, my lord, it is the desire of the court that 14, my lord passed an order under section 14 that I got.
Yes.
What is the provision for the purpose of charging extra amount rather than rent and other things that I have got. On that basis, my lord, if your lordship allows me to, I'll make 5 or 6. Only that portion, if you like.
So I'm keeping it day after tomorrow.
As your lordship.
Day after tomorrow, because my lord, the Ivan Roy, the advocate on record, he is suffering from fever and mumps. So instead of day after tomorrow, if it can be taken up in the next week.
All right.
As your lordship.
Next week at date দিয়ে দিন Monday or Tuesday.
Monday, Tuesday.
Monday date টা লিখে রাখুন।
As your lordship.
Let's call the next matter. আচ্ছা ওটা একটা order record করে দিন on the prayer of the he is for the
We are for the decree holder opposite party.
Decree holder opposite party. You are
Yes,
for the
Lord.
petitioner, yes.
Yes, my lord.
Yes.
My lord, this is against an order, my lord, passed under sections 47 of the Code of Civil Procedure, my lord.
Yes.
My lord, before starting, my lord, I just want to draw my lord's attention. The initial order passed by my lord Justice Shampa Sarkar and lordship has pleased to formulate the points of law, my lord, in this matter, my lord. That is, my lord, the order dated
Order dated
3rd of January 2024. And lordship has been pleased to formulate the order
January 2024.
2024, my lord.
Where is the compromise decree?
My lord, that compromise.
The suit was decreed on compromise.
Yes, my lord. Yes, my lord.
Page 17 to 19 is
Where is the compromise decree?
My lord, that compromise degree, my lord, at Annexure B, page 15, my lord. That is in Bengali.
Annexure B, page
15.
that is a compromise petition.
Compromise petition degree was passed on the basis of that.
that was made part of the decree.
Yes, yes, yes.
Page 15.
Page 15, my lord. Yes, Bangla in Bengali, my lord. Annexure B, page 15. No? আপনার মিলছে?
Annexure B.
Yes, my lord. That is in Bengali, my lord.
Yes.
The shoot property is a shop room, my lord.
So a decree of partial eviction.
No, my lord. My lord, that was not the, my lord, that was not the case, my lord.
No, clause number 3 at page 16. নালিশি গড়ের 5.5 ফিট চওড়া অংশ ব্যতি রেখে বক্রি অংশ বিবাদী ভাড়াটিয়া হিসেবে ব্যবহার করিবে।
But that is not in the not in the compromise degree, not in the order itself, my lord.
No, in the compromise petition, page 16.
Yes. My lord,
Point number 3.
নালিশি গড়ের চওড়া ব্যতি রেখে বক্রি অংশ ভাড়াটিয়া হিসেবে ব্যবহার করিবে এবং বাংলা সাল অনুযায়ী প্রতি মাসে 80 টাকা করিয়া ভাড়াও আদায় দিবেন। Well, that is true, my lord. Logically, see, there must be some finding, my lord, in the compromise degree that any of the grounds specified under section under the West Bengal premises standards, that is clause 13, must exist, my lord, and court must record its satisfaction. But court must record its satisfaction, my lord.
Where is that judgment?
My lord, I'm placing your lordship, my lord.
Where is that judgment?
My lord, judgment I am placing, my lord. Before that,
Yes.
your lordship can consider.
Yes, Talk. What do you say?
Yes, Lordship.
What do you say to this?
My lord, kindly look at
Compromise decree in a suit for eviction without recording satisfaction as to the grounds of eviction contemplated under section 6 or 13, whatever.
13, my
decree.
lord. This is an old act. Under the old
13. Whether it's a valid compromise decree. What do you say? Where is the decision?
My lord, I am placing, my lord, judgment time, order 23, my lord. Court must record his satisfaction, my lord.
So you have not brought those judgments.
His judgment, yes,
Where is
I
that?
have, my lord. I have, my lord.
Give me that.
My lord, first judgment, my lord, of the division bench of this court, my lord, reported in Calcutta High Court Notes, 1982, volume 1, page 410, passed by the division bench, my lord.
Page citation 19.
Calcutta High Court Notes, 1982,
1982,
volume 1,
CHN,
CHM, page 410. Malad, that is the judgment of Justice A.K. Sen and B.C. Chakraborty, Malad, division bench. Malad, paragraph 12 onwards, my lord, if you lordship kindly come to paragraph 12 onwards.
Well,
yes, Mr. Hawk, what do you say?
My lord, kindly look into the degree. Kindly look into the judgment being passed.
Yes,
This is at page 17, your lordship.
page 17, yes.
My lord, both the parties filed compromise petition, duly signed themselves on the grounds stated in the petition. Hard prayers recalling a PW1 is considered an allowed PW1 and DW1 examined and cross-examined, discharged. Peruse the compromise petition along with the evidence on record. It would be seen that dispute in between the parties have amicably been settled in terms of the compromise petition. Both the parties have stated that the dispute have been settled in their deposition. They also deposed, stating that they want to get compromise decree as per terms and conditions in Solenama. Parties of the case and their advocate have also put their respective signatures on the Solenama after knowing the contents of it. Accordingly, the above facts and circumstances goes to show that dispute in between the parties have amicably been settled. As such, the suit should be decreed on compromise.
Where is the satisfaction with regard to the grounds under section 13? Nothing has been recorded. Not in the compromise petition also. That's the
But
decision.
That is, my lord, the discretions of the parties. The parties had filed the application. Your
Sir, have
lordship.
you considered this line of decisions?
That I have not, your lordship. That is there.
When do you want? tomorrow?
But my lord, kindly look into the order, my lord, challenging the order, your lordship, they have come before the court,
Yes,
come before this honorable court. My lord,
Sec-
kindly order number 159. 159 dated 18/10/2000.
wait, I will come to, are you ready? If you are ready, I can take it up today.
My lord, that I have to look into it. That
So
I will
look-
look into it. Yes.
Look
my lord.
into that, come tomorrow.
Come tomorrow. Obliged, your lordship.
Yes, tomorrow, my lord, my learned advocate has some difficulty. Advocate on record.
Day after tomorrow,
After tomorrow, call it.
28th. You will not be available for this week. When is the execution fixed?
Execution. No, execution case, well, date. Well, the date has not. You know that.
All right, heard Mr. Gupta, learned advocate. Yes, to take back. Why? Let it remain,
My lord, I have no difficulty, my lord.
because I have said to consider that.
Yeah.
time.
Yes.
Yes. But then don't mention for upgradation. Be sure, don't mention for upgradation then. I'm making it out of list, you mention it for inclusion. The learned
But I am for the petition. But plaintiff appellant before the appellate court, my lord, is the petitioner before your lordship. By the order impugned, my application under order 41 rule 27 has been turned down. My lord, I in my application categorically stated, my lord, it is a suit for declaration and permanent injunction. I am claiming, my lord, derivative title by
appeal is pending.
appeal is pending. And my lord, I categorically stated that yes, in one point of time, I
The
submit.
application is such, it's not worth consideration, Mr. Mukherjee.
That can be. That's why I want to, my lord, address before your lordship, my lord. But the law, your lordship, no.
It's not worth consideration at the time of hearing of the final appeal.
That I will satisfy before your lordship.
Yes.
That my application.
Where is your application?
My application that starts with, Lord, page 37. Lord, even I have mentioned these record of rights, RS and LR. Once in a point of time, I submitted before the trial court. And thereafter, for the other, my lord, proceeding, I withdraw it.
What is the suit for?
Suit for declaration and permanent injunction. Lord, why these record of rights are necessary? I am claiming through by virtue of a deed. But regarding, my lord, the derivative title, in one point of time, through whom I am tracing my title, there was an amicable settlement between the heirs, brothers. So that has been reflected in the record of rights.
You are the appellant.
I am the appellant, plaintiff appellant.
So dismiss.
Suit dismissed only on that score. Defendant's
Where
case
is
is of adverse possession.
Where is the judgment?
Yes, my lord, kindly takes up, my lord, I have annexed the judgment. Judgment, my lord, starts with page 23. The relevant portion, my lord, I have kindly takes up. The relevant portion is at page 34. 34 top, your lordship kindly reads. Because all these deeds have been exhibited, the court has negated my case only on the basis of that settlement. I could not able to prove that amicable settlement between the brothers through whom I am tracing my title. And the defendant's case is of adverse possession. Court recorded that he could not able to show anything.
There is substance in the argument of Mr.
I appear for the petitioner.
Yes.
I'm appearing for the opposite party, number 6 of the opposite parties, my lord.
But I filed a suit in the year 2008. And I filed, my lord, an application for withdrawal of the suit, my lord, into
With
the
liberty to sue afresh.
No. Unconditional.
Yes, what happened? to
Now,
that?
my lord, thereafter, my lord, I filed the my lord, application for withdrawal. Thereafter, my lord, the defendant, 3 of them, 3, 4, and 16, filed, my lord, a written statement with counterclaim after I filed the application. The learned judge, my lord, by an order, my lord, accepted, my lord, the counterclaim and, my lord, dismissed my application, my lord, for withdrawal of the suit. I came up before this honorable court. This honorable court set aside that order, directed that my application for withdrawal of the suit should be heard, my lord, prior to the application, prior to their acceptance of the counterclaim. It went back. After it went back, the learned judge passed the impugned order. Your lordship will kindly come to the impugned order for once.
What has been done in the impugned
Lord,
order?
I rejected my application for withdrawal.
Counterclaim?
The counterclaim, Lord, that was not that was not the subject matter here as of now, because Lord, the
Counterclaim has been accepted.
no, not yet, because Lord, the honorable court
Mr.
said that
Mukherjee, the counterclaim can proceed even if you withdraw the suit.
no, the acceptance of the counterclaim was set aside by this honorable court in the previous order. The honorable court said that you first hear my application for withdrawal. My application for
Mukherjee, you
withdrawal.
said, the counterclaim dependent on
I'm
the
not
suit.
on that. I'm not on that. The court has refused, Lord, my withdrawal of the suit. That is all.
Show me.
Your lordship will kindly come to the impugned order, a 1-page impugned order, Lord, 17th of December. But the reasoning given by the learned judge is not the last 3 paragraphs. But,
Where is your application for withdrawal?
page 29.
And where is the earlier order passed by this?
Yes, that kindly see, Lord, page 37. Lord, page 38, Lord, that is the operative portion.
Mr. Mukherjee,
But
If
the
the
CEO
suit,
by directing the learned civil judge junior division first court Bakura to decide the application filed by the plaintiff for withdrawal of the suit first,
yes.
and thereafter shall consider whether the written statement of the said defendant can at all be accepted or not.
If the suit is withdrawn,
Lordship.
where this consideration of the written statement.
But I'm not on that. I'm only on, my lord, whether, my lord, the learned judge could have, my lord, refused my application for withdrawal of the suit.
This is that is.
I'm not on whether, my lord, there, my lord, the counterclaim will proceed independently or whether it should be accepted or not. I'm not on that. But why do you compel me to proceed with the suit when I'm otherwise, my lord, unwilling to proceed with? It is not with the leave to
Yes,
proceed
what you
afresh. And the reasoning of the learned judge, my lord, so far as the affidavit is concerned, factually incorrect. There is a shotto part. Secondly, the requirement of an affidavit is when, my lord, a leave is sought on behalf of a minor.
Yes. Yes.
My lord, if your lordships kindly comes to, my lord, order 23 rule 1, my lord. My lord, therein, my lord, kindly comes to, my lord, subclause 3, where the court is satisfied that a suit must fail by reason of some formal defect Or number B, my lord, that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or part of a claim. It may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or such part of the claim with liberty to institute a fresh suit in respect of the subject matter
That's for
of which suit is the part of the claim, my lord. My lord, if your lordship kindly comes to page 29, my lord, once.
Page
Page 29 of the application,
29, yes.
wherein, my lord, they have made the prayer for, my lord, withdrawal of the suit. My lord, first of all, my lord, there is no reasons mentioned. Second, my lord, if your lordship kindly comes to the bottom, my lord, only Sitaram Salampuria has, my lord, made this affidavit, my lord. There are four petitioners, plaintiffs, my lord. Only out of which Sitaram Salampuria has signed this prayer, my lord.
Yes.
And my lord, your lordship kindly sees, my no reasons, no sort of reasons has been mentioned in this prayer, my lord. My lord, the learned judge has rightly, my lord, passed this order not to withdraw this suit, my lord, without any sufficient.
Anything more?
My lord, that's all.
my learned friend is তুমি কার হয়ে অ্যাপিয়ার করছো ভাই? ছজন? But so far as my learned friend is concerned, as I know, my lord, they are running ex parte, the defendants. The written
You are
statement
appealing
was
for which of the opposite parties?
My lord, 2, 4, 6, 8, 12, and 15.
They are
4
ex parte.
has filed the counter claim.
Defendant number.
So,
Defendant number 4.
so he is appearing for one of the
But
defendants.
I do not know whether he corresponds to defendant number 4 or not.
Please
Because
check up
Lord,
that. Where is the plaint?
Lord, a plain dear lordship will find at page 16.
So, yes, sir, please tell me from the plaint, whom you are appearing, for whom you are appearing.
My lord, defendant number 2,
Defendant number
Defendant
2,
number 2 has not filed the written statement.
my defendant number 4,
4 Subra Chatterjee has filed the written statement.
yes. So he is one of the,
And 16 has filed the written statement.
so he is appearing for those 2, 4 and 16, he said.
2 has not. 4 is yes.
4,
16. Are you appearing for 16?
No, no.
ওরা কার হয়ে appear করছে?
no, my lord, I am not appearing for 16, my lord.
So you are appearing for 2, 4 and
2, 4, my lord, in the defendant, and my lord, 6. In
6.
6 is Lord ex parte, running ex parte.
But Mr. Mukherjee, 4 is there.
4 is there. I don't say.
So-
3, 4, 16. They are not the.
Yes,
person
you are
who
appearing for whom?
I am appearing on top of respondent number 3 and 18.
3 and 18. Have you filed your written statement?
Yes, 3 has filed.
Yes, file the written statement.
Yes. 3, 4 and 16 filed the counter claim.
Oh, 3, 4 and 16 file the counter.
The counter claim.
So now here they are
There are 2
filed.
sets of lawyers. I do not know, Lord,
This is being done now, Mr. Mukherjee. Plaintiffs are also contesting by different
Like
claims.
I'm also not confused to address to whom, Lord. That is the reason I asked
The
my
plaintiffs are also now contesting by different lawyers.
No, Lord, plaintiffs are
No, not in your
Oh,
case.
no, in other matters.
In other matters also, plaintiffs are
Good
have a
for the
point.
profession, but not good.
Yes, what do you say?
First of all, my lord, order was passed in 2021, my lord. My lord, kindly see order 2021.
Yes.
My lord, and 2020.
Madam, if they do not appear, can you compel them to appear? Let us assume, yes, this order remains. And from tomorrow, they stop appearing. Can you compel them to appear?
No, no, my lord.
So what will happen? The suit will
2020.
proceed in their absence also. What's the law? Let us assume tomorrow, from tomorrow, they stop appearing. What is the law? Ashun, this application under Article 227 of the
I'm grateful.
Dependent is the petition if your lordship is sued for eviction.
Dependent number,
Defendant is the petition if your lordship.
defendants,
Depend-
one dependent.
No.
Many defendants. Yes, defendants are the petitioners. Yes, what is the impugned order?
Impugned order, my lord, the initial application for amendment was allowed. If your lordship may kindly turn to the order dated 15th April 2024.
15th April 2024.
Yes,
Application for amendment of
written statement.
written statement allowed.
My lord, got it?
Yes,
Now, my
you
lord,
cannot be agreed by that.
now, my lord, can you turn to the order impugned?
No, not the written statement.
Yes.
Plaint is allowed. It
Indeed,
says for
at the
filing
same
of the-
time, the proper adjustment of the dispute, court may allow at the sort of amendment. It does- Hence, the said amendment sought by the plaintiff, it should be just be as it, and the petition order 6 rule 70 is allowed on contest without any cost. The filing amendment 10, additional statement,
So plaint was allowed.
plaint was,
You said. Written
sorry,
statement.
I beg to be corrected. Plaint was allowed. Now, I can turn to the order impugned.
Happens, Mr. Rai, you are mixing with other matters. Yes.
I can turn to the order.
So this is not under challenge.
No, not
So amendment allowed.
yes.
Yes.
Normal kind takes up the order. That
What is the impugned order?
yes. 31st March, January 2025. Your lordship can turn to 31st
Yes.
January 2025. Your lordship will find this is the plaintiff number 2. I got it last but one. On peruse, it says the plaintiff number 2 similarly public has died 3-4 years ago, which privacy appears to be beyond the period of limitation by operation of law, and no cogent reason has been given by the plaintiff as to why they did not file any substitution application 2020.
So suit was abated as against the plaintiff number 2 and liberty given to take steps for setting aside abatement.
So
This you are challenging.
no, this is the order passed. I have to take steps or
Not you.
no, plaintiff.
Yes. You are mixing, Mr. Rai. You are saying you are the defendant. You are
No,
saying
no.
I have to take steps.
Now you will actually turn to last order.
Why are you aggrieved by this?
Last order.
So 31st of January you are not aggrieved.
31st January on the other ground that the court has given the period to for setting aside amendment. Hence the amendment petition dated 30th September 2024 stands rejected. Manlat Kali got it after that.
Yes.
The amendment is the prayer for amendment of the registered which I have filed. That is why, Manlat, at the top your lordship find to the fixed for hearing application amendment and filing of it.
But amendment was not considered.
Yes, it is rejected. Yes,
But nothing on merits.
nothing. Rejected.
That is your application for amendment.
Now, Manlat can turn after that, Manlat, after placing the order, Manlat can
All right.
6/5/2025.
Yes.
For the plaintiff has filed and Hazira moved an application for under order 22 rule 4 sub rule 4. This is an application filed by the plaintiff because they are expunging the name. Whether the expunging is permissible or not. After abatement.
There are two line of decisions.
After abatement, whether 22 for expunging.
There are
is
two line of decisions. Two decisions are there. One says yes, can be.
One is Mr. Jibanathan Chatterjee. He argued in a matter. If you want to take advantage of order 22 rule 4 sub rule 4 or expunging, then you have to make it before recording of abatement. But some judgments are that there is no provision of the time limits mentioned in order 22 rule 4 sub
That
rule
is
4.
why I have said two line of decisions.
That is why, well, these are the arguable case, your lordship.
Mr. Rai, the larger part is the larger issue is whether the
Amendment.
Please take up order 22 rule 4 sub rule 4. It applies only in the case of a death of the defendant.
No, the parties well subject to
Please take up order 22 rule 4 sub rule 4. Don't have the CPC.
No, no.
Mr. Rai. Yes, take it. দিয়ে দিন দিয়ে দিন দিয়ে দিন।
এই, কোথায় গেল? এই, দিয়ে যা।
সব মাথায় আছে।
না, না,
Yes, yes.
মানে
Yes, take it back.
it is better to give me a slap rather than provide you a six.
Yes.
Sir,
Yes, place it loudly.
yes, procedure in case of the death of the one of the
Yes,
several
order
defendants.
22 rule 4, sub rule 4. Directly come to sub rule 4.
Sub-rule 4. The court
Yes.
whenever it thinks to exempt the plaintiff from the necessity for substituting the legal representative of any such defendant. Well,
Yes.
so it is restricted according to the restricted.
So
So this
that
was-
is why I told you.
But
How can it apply? Because Mr. Rai, the logic is a defendant who has not filed a written statement, who is not contesting. That cannot be applied to a plaintiff because he has filed jointly the plaint. So this logic cannot be applied to a plaintiff. How can it be applied? It only deals with relates to defendant, not the
that is why
plaintiff.
an application expunging of the expurge also is not permissible.
So order 22 rule 4 may not be permissible.
Order on rule 10 also not be permissible because where joint plaint, if the all the plaintiffs
But
What
the
is-
case is, if suppose one of the plaintiff dies, leaving the right to sue does not accrue to others. It accrues only in favor of the surviving plaintiffs. Whether there is necessity to substitute, then expunging can be made.
yes,
What's the case here?
Here.
Where is the application for expunging?
and before that one
The application, where is the application for expunging?
that your lordship will find at page 30.
30.
30. Page 30, my lord, last first paragraph, last 3 lines.
Page 30, last paragraph.
Last but first paragraph, last 3 lines.
Ultimately, the partition finally decreed plaintiffs become the joint owners. After becoming the joint owners, the plaintiff jointly instituted the suit on West Bengal premises yet, but unfortunately, this is the eviction suit.
Eviction suit.
Unfortunately, plaintiff, the daughter of the original owner, died during the right to sue survives to the. Yes, that's their case. It survives only upon the surviving.
Surviving.
So they have expunged. So you can take.
landlord, they are the landlord. They are
Yes.
the landlord, I am the tenant.
Yes.
If the joint application it was filed where it states that the right to sue survives to the
But,
surviving plaintiffs alone, whether it is
Where have you stated that she left behind other heirs?
yes,
These are the
mankind at
heirs.
page 33.
Yes. Tell me who are the heirs? Where have you stated?
Yes. If your lordship can turn to paragraph 6.
Yes.
Self-reason matter of the plaintiff also is strongly denied after demands plaintiff to right to survive upon the
You
surviving.
are only denied, Mr. Rai. Mr. Rai, you have to tell that no, she died leaving behind such and such. So that you have not stated. And their case is that upon the death, it survives upon the other surviving plaintiffs. What's the necessity for substitution?
Well, their application, your lordship, they did not say that he died without any legal heirs. But if only they said, my lord, kindly consider. What is the statement made?
Mr. Rai, they have said that upon the death, the right to sue accrues to the surviving. So now you have to state no.
The
You have to
surviving
make
plaintiffs
out
alone.
the
Surviving plaintiffs alone.
Yes.
That's the statement made.
Yes.
Now, my lord, kindly consider the order passed, impugned order once.
Yes.
The plaintiff, namely, property that died during
Yes, without any legal heirs.
without any legal heirs, accordingly, my lord, where the court is come to findings that without any legal heirs. One can go in their application, they have stated,
No, did you say, Mr. Rai, that there are
Denied.
legal heirs?
I have denied. But the application, whether it has
Even without that, they have said that right to sue accrues to the surviving plaintiffs. So if you have to come out, deny that, mere denial will not do. You have to come out with a positive case.
Yes.
That she left behind such and such heirs, so right to sue also survived upon them.
No, And I want to bring the said fact by amendment or decision, because my case is that
Where is that application for amendment?
your lordship will find page 27. Serial of amendment, my lord will find. What is query made by your lordship, my lord? That is there in the serial of amendment.
Yes. So, Mr. Rai, even if your amendment is allowed, you proceed with your
My
application.
amendment is rejected.
No, yes, that's a different thing, but that for that
No,
reason-
my lord is asking whether I have clearly stated whether there is any legal error.
No, that is the right. That's the application for amendment, not in there that written objection you have
So
not stated.
therefore, my lord, it proceeded as if
Show me the consideration of your application for amendment.
one line. Pay order number 31st January 2025. And this is the application of the Annexure C, my lord, left hand corner, top, the date of filing of the application. Because nothing has been said so far by application for amendment is concerned. Only
In amendment, the plaintiff has supported you.
in spite of that, it was rejected. BSB, I am not going into that also. The last consideration.
This is the application dated 30th of
Yes,
September.
left hand corner, my lord will find.
Page.
Page 27, left hand top. I got it. Trouble.
There
I'm bottom.
Yes.
Plaintiff is the petitioner before your lordship. It is expeditiously to the injunction was granted 4 January.
Expeditious hearing of the injunction application.
Yes, yes. And even my lord,
Objection has been filed.
no my lord, even posted as ex parte, but till now my lord has not been heard. Ex parte my lord, 18th May 2024. Order.
This application under Article 227 Yes. First part of the order. What is the first part of the order? Which order? 13th of January. Yes, which order you are, which portion you are challenged? Please use the microphone.
Written statement has been filed after 35 years.
Oh, you are not challenging the 151 portion.
Yes, sir, that I have only challenge. That has been rejected. Against there. Only 1,500 cost, written statement can be allowed. But second portion is not necessary at all.
What is the suit for?
Good for injunction.
So why are you trying to delay your own suit?
Injunction.
Why are you trying to delay your own suit? Written statement has been filed. Service returns in respect of the defendant number 3. So the suit is not yet ready. You cannot proceed with the suit. Even if the defendant has delayed, you cannot proceed with the suit because the service returns about the defendant number 3 is yet to be effected.
Earlier order, my lord, you will only see, my lord. That is, my lord. The original initial, your lord, you can see earlier order. That has not challenged, my lord. Earlier order.
Yes.
22.
So you have not challenged that.
That is my rule.
Then
But you are not consumer at that point, my lord.
this application under Article 227 of the Constitution dismissal. Thank you, Mr. Manager.
Number 11.
Yes. Yes, yes. Please use the microphone.
My lord, last page of the order, my lord.
Yes.
My lord, amendment application in connection with application under order 9 rules 9 was allowed, my lord.
Yes. What is the amendment?
My lord, kindly see, my lord, the order of dismissal, my lord. Order of dismissal of the suit.
Order of dismissal is cannot be gone into now. Show me the amendment application.
My lord, I am coming, my lord. Page, my lord, 13, my lord. Kindly come to
1-3.
1-3.
Yes.
1-3, my lord.
Yes. Suit was dismissed for non-prosecution.
Non-prosecution, my lord, he was so caused, but plaintiff did not take any steps in spite of repeated call and
That is why our order 9, rule 9 has been filed.
my lord, kindly see the order 9, rule 9 application, my lord, page 15 and 6. Page 15, coming to page 16, my lord, middle portion. Page
Yes.
15, my lord, order 9,
Yes. Page
rule 9
15,
application.
yes.
It was filed on 9th January 2020, my lord.
Yes, yes.
9 January 2020. My lord, page 16, my lord, middle portion. বাদীপক্ষ গত ইংরেজি 25/12/2019 তারিখে আকস্মিক জ্বর ও জন্ডিস জনিত কারণে অসুস্থ ও শয্যাশায়ী হইয়া পড়েন। বর্তমানে তার চিকিৎসা চলিতেছে। এ কারণে বাদীপক্ষ গত ইংরেজি 7/12/2019 তারিখে মোকদ্দমার ধার্য দিনে হুজুর আদালতে আসিয়া যথাযথ কারণ দর্শাইতে না পারায় মাননীয় আদালত উক্ত তারিখে মোকদ্দমা খারিজ করে দেন। মানে কেস ওয়াজ ডিসমিসড অন 7th December আর হি ওয়াজ সাফারিং 25th December. Before suffering, my lord, case was fixed. 7th December. He was suffering on 25th December. Then, my lord, kindly come to page, my lord. Application was filed by affidavit, my lord. Then, my lord, section 5 application, my lord, page 20. Page 21, my lord, also page 21, my lord. কিন্তু ততপর বাদীপক্ষ গত ইংরেজি 25/12/2019 তারিখ আকস্মিক জ্বর ও জন্ডিস জনিত কারণে অসুস্থ হইয়া পড়েন। বর্তমানে তার চিকিৎসা চলিতেছে। এ কারণে বাদীপক্ষ গত ইংরেজি 7/12/2019 তারিখে মোকদ্দমার ধার্য দিনে হুজুর আদালতে আসিয়া যথাযথ কারণ দর্শাইতে না পারায় মাননীয় আদালত উক্ত মোকদ্দমা খারিজ করিয়া দেন। বিফোর সাফারিং, my lord, case was fixed, my lord. He did not appear, did not submit so-called reply. Then, my lord, kindly page 21 bottom, my lord. Page 21 bottom. Plaintiff 21 bottom.
Yes.
Plaintiff also filed prescription, my lord, dated 25th December 2020. 25th December 2020. And this application was also by affidavit filed. And, my lord, after 4 years, my lord, amendment application. After 4 years. Then, my lord, kindly come to after 4 years. Page 29.
What is the suit for, Mr. Dewan?
Suit for declaration of title and permanent injunction. I am suffering, I am the defendant. I paid the amount of rupees 50 lakhs. Allegation that mortgage deed was converted to a sale deed. This is the allegation of the plaintiff. I am in position, I am residing in the building. Evidence started in the year.
So according to you, on that date, he was not ill. He was,
Yes, my
he
lord.
produced documents from 25th of December 2019.
2019.
So from
Misleading the court, my lord.
that is the matter of proof, Mr. Devan.
No, my lord, kindly. Then, my lord, he takes in the amendment of his application takes steps that is a bona fide typographical mistake, shifting the medical. She is suffering. He is suffering medical. That person was changed. My lord, kindly see that is the page, last
Mr.
page.
Devan, after all, it's an application for restoration.
My lord, I am 2015, my lord, evidence started. Due to the part of plaintiff, my lord, opposite party, I am suffering since 2015, my lord.
This application under Article 227 of the Constitution of India matter.
Malad, if possible, Malad, kindly direct the court below trial court to complete the trial, Malad.
Trial or the miscellaneous case.
No, Malad, mission.
It's now the miscellaneous case, order 9 rule 9. It's
Order
not the
9
trial.
allowed, Malad.
Amendment allowed, not order.
Amendment along with the order 9 rule 9 application,
Rule.
Malad.
How
Malad,
can it
kindly
be? Amendment allowed. Miscellaneous case is pending. Yes.
This matter arises out of the non-consideration of the application under section 36 of the special manager seeking pendant alimony pendant right, which is pending before the first track court in Howrah. Now, earlier, the respondent husband has been persistently filing applications one after another, seeking adjournments. And those are being allowed by the court, learned trial judge at Howrah.
What happened to the, you are the wife?
Yes.
You are the wife.
Yeah.
What happened to the miscellaneous case?
Miscellaneous case.
Yes.
I take your lordship to page 29. Earlier, the
No,
husband.
no, what happened? The pending.
That has been kept pending, where directions were given for assigning precedence to the application under section 36. That has been kept pending. And the match suit, what was ought to have been stayed, it has been it is being heard day by day. And now the match suit has been heard, fixed for peremptory hearing, in spite of the direction of this honorable court. And the direction of this honorable court is at page 29.
So the miscellaneous case is pending.
Miscellaneous case is pending. The petitioner has a child, 11 years old. She is in agonizing existence. And the other side, the respondent has overlooked, ignored considered the welfare, well-being of the child. Now, under that order, in your lordship will be pleased to find that at page 30, that the court dispenses with the service of the notice with a direction upon the learned additional district judge first track court Howrah to dispose of the application for maintenance pendant right within a period of 4 months. That order was passed as back as 23 June 23. But repeatedly adjournments are being granted. And in the meantime, the learned trial judge demitted his office, new incumbent, extended facility of hearing the application affairs by allowing application.
The advance of the petitioner is that the learned trial judge
I am for the petitioner, husband petitioner. It is an application for early disposal of a matrimonial suit. Malad, evidence started, but dates have been given.
miscellaneous case, alimony.
Well, that has been, they have not prayed for any alimony because she is working and I am also working. But can you see, 8 dates have been, or 9 dates, Malad, for evidence. Evidence started, but it has not been completed. Malad, therefore, my humble prayer is to dispose of the matrimonial suit, Malad, for direction, including the evidence.
This application under Article 227 of the Constitution.
But here, plaintiff filed the suit in the year 2008. Well, I have annexed every order, but kindly see, well, 31 dates have been fixed for commissioner report. Ultimately, the commissioner was examined and the matter was heard. Thereafter, the court was changed and the learned court by order number 173 directed for fresh hearing. Now, my lord, my client filed two applications. My lord, for the application, my lord, kindly see page one for exemption of service and also, my lord, for acceptance of the commissioner report to be heard along with the main trial. My lord, let this matter be two matters be disposed of along with the suit for early disposal.
What are the applications?
My lord, kindly see, I have annexed. One
7th
application,
of September 2024.
my lord.
Where is that?
My lord, I have annexed, my lord.
Page?
Page. Now, after the type copy, my lord. Another application for exemption of service, substitution. Have you also got it? Investigation Commissioner report accept হইবার জন্য argument along with main trial or personal also. And the British plaintiff is aged about 95 years. I also stated 90 years. Well, sorry, 90 years.
This application under Article 227 of the Constitution of India.
Lord, the defendant in a suit for declaration and permanent injunction is a petitioner before your lordship. Lord, suit for declaration and injunction. The plaintiff made out a case that he purchased 8.4 decimals of land of that number 297.
What is the order impugned?
The order impugned, Lord, granting police help for implementation of the order. Lord, kindly see the order itself, an injunction order.
Where is the injunction order?
Lord, injunction order, your order sheet has page.
Page?
Lord, it is not 15, not paginated. Order sheet, Lord, this is the certified copy.
Yes, from disturbing the defendants are restrained from disturbing the peaceful possession over the suit property and from changing the nature and character of the same till such and such.
Yes. Lord, kindly see before that. It is the operating part. Kindly see the order, nature of the order. After.
Yes.
Nothing has been considered. Simply
that is with regard to the injunction.
Then I am coming to that, your lordship. Kindly then, Lord, the returnable date your lordship will saying was fixed on 20th February 2025. Returnable date. Lord, before that, by filing a put-up petition, I entered appearance and filed WS on 14th December 2024. Thereafter, in the meantime, the opposite party P20 filed an application under section 151 on 27th January 2025
Police help.
for police help. And my lord, on returnable date, I filed written objection against the injunction petition. All are there. Thereafter, the learned court will fix both the matters for hearing on the next date, that is 6th May
Yes.
2025. And my lord, in the meantime, I was directed to file written objection against 151. On that day, it was filed. It has not been recorded. My lord, can I now, my lord, kindly read the order impugned from the very beginning.
Where is the written objection to 151?
So, Lord, your lordship kindly see that is the last annexure.
So what is your claim? You are in possession.
No, I am in possession. Your lordship kindly schedule of the my deed and their application.
Where is your written objection to the injunction application? No, to the 151 application.
Page 59.
59?
Yes. I have purchased the property in 2007, constructed an industrial building and running my business. 200 workers are working. And my lord, your lordship kindly see just schedule.
By the order impugned, the
Number 16.
16, Lord, I am for the petitioner. Lord, there is a caveat, Lord, I have started upon the caveat.
I am for the opposite party.
Lord, the order impugned is this, Lord, the in eviction decree has been stayed without granting, Lord, the occupational charges. Lord,
without granting the occupation charges.
yes, Lord. Lord, the suit for eviction of the licensee, that suit was decreed ex parte, Lord, the he,
No. Occupation charges have been granted.
no, Lord, the kindly see.
6,000
One time.
one time. So till the next date fixed. So date has been fixed on 20th of September.
Yes, Lord.
The-
20th of September, it will be decided, the quantum will be fixed.
Nothing has been observed by the learned trial.
Please,
Kindly observe these things.
it has been observed. Please take the last paragraph of just before the order as prima facie.
Yes.
There is sufficient scope of argument from the end of the appellant. I am of the opinion that
Bloody-
there is justification in the prayer of the appellant, and accordingly further proceedings of the execution case pending is stayed till the next date fixed, subject to payment of such and such to the respondents. Appellant has already filed the requisites. Same is issued to 20th of September for receipt regarding payment of condition of stay. LCR service returns. So it has been made clear
Lord,
till the next date fixed.
till the next date fixed, Lord, but kindly consider one more thing, Lord, that order was passed without giving me any opportunity of hearing first, and second thing is.
Sir, that was an at the interim stage. At interim stage, you have been they have been directed to serve upon you.
Lord, kindly
So
observe.
for a limited, the court could have said unconditional after hearing. Instead of that, court has directed some amount to be paid.
Lord, kindly observe.
Have you appeared?
No, Lord, no notice has been served upon me.
Sir,
She served,
No, Lord.
as usual, course, lordship requisite filed, thereafter notice has been served.
Then I will file the requisites.
Lord, kindly.
On the
All right, you enter appearance 20th of September.
September, lordship.
Now you have got these copies.
I got the certified copy.
All right. So you enter appearance in the executing court. I will give you liberty to file an application for payment of occupation.
Payment of the occupation, sir.
This application under Article 227 of the
Item number 17, Your Lordship, I am appearing on behalf of the opposite party, Mr.
Yes,
Shonak
you are for the
Bhattacharya.
petitioner. Yes,
Mr. Shonak Bhattacharya is appearing on behalf of.
since I am not inclined to take up this matter on personal.
18. But I am for the petitioner. But plaintiff is the petitioner before your lordship. But plaintiff filed a suit for declaration of title and injunction. In that suit, order of injunction was passed. But order of injunction is at page 29. And against that order, the opposite party filed appeal, miscellaneous appeal. And appeal court
rejected the prayer for injunction. But page 29 is the order of injunction.
Yes.
But
Show me the order passed by the, show me the plaint.
plaint is of page 20. Sorry. Page 9 starts.
Page 16 is the prayer.
16 is the prayer.
Yes. Show me the order of application for injunction, temporary injunction.
Temporary injunction, my next page 19 onwards. Petitioner is the owner of the land, Malad. Opposite parties are not the co-sharers. But that has been held in
Banerjee,
Malad.
if this injunction is granted, what remains to be decided in the suit, Mr. Banerjee?
But final relief has been granted, Malad. The final relief has been
So,
granted.
what remains in the suit? Can that be granted at the addendum stage?
But Malad, the lower appellate court has passed order, Malad, page 3, paragraph 4.
Where is the order of injunction passed by the learned trial judge?
Malad, page 29. May I read, Malad? And on careful perusal and consideration of the materials on record.
Actually, the suit has been decreed, Mr. Banerjee. Can it be done?
So, Malad,
Rightly reject this application under yes.
My application, when there is
Yes, Mr. Banerjee.
This is from Milord an order allowing Milord the plaintiff's application under Order 11, Rule 12, read with Rule 14. Milord for interrogatories and production of document, Milord at a stage when Milord my 711 has been rejected, from which Milord I have preferred a civil revisional application, which is also Milord pending Milord as item number 339. Milord on the last occasion, Milord Mr. Chatterjee was Milord leading me in that other matter. So Milord I say here, Milord the learned court lacks Milord inherent jurisdiction. And Milord this is an incurable defect because Milord this is out and out ex facie commercial dispute. And Milord section 12 has not been complied with. Now, Milord, leaving those things aside, Milord, just at the drop of the hat, Milord, if I may say so, Milord, an application under Order 11, Rule 12, read with Rule 14 is allowed for production of a document which is already there, Milord, on record. Milord, this is something unusual.
That is already on record.
Photocopy is already on record. Milord, Order 11, Rule 12 or Order 11, Rule 14, Milord, applies when, Milord, I obstruct Milord production of a document. And Milord, the learned court is of the view that Milord, I am trying Milord to obstruct the stream of justice. Here, Milord, the plaintiff himself has Milord relied on that document. But the partnership deed is Milord the document which the plaintiff Milord wants me Milord to produce.
But you say the court lacks jurisdiction. That order.
So, Milord, yes.
So I'm directing this matter to be heard along with that.
Yes.
List this matter. Mr. Learned advocate appearing for the petitioner submits.
Next, item number 20.
Yes.
Lordship.
Yes, 20.
Milord, I think my learned friend was appearing in my matter.
Yes, Lordship, I'm appearing on that matter.
In which matter?
Item number 19.
Item number 19.
19 you are for the opposite party.
Opposite party, Your Lordship.
All right, so I've directed the other matter, Order 7, Rule 11, Civil Division, to be tagged along with this, and it will both these matters will appear in the next week. Opposite party appearance টা record করে দেবেন ঠিক আছে আগেরটাতে item number 19 yes who is appearing in the next matter?
Lord, I am appearing on behalf of the petitioner.
Yes.
Lord, I am the defendant in a suit for eviction of licensee, Milord. Kindly, Milord, comes to the impugned order, Milord. Milord, I am challenging portion of the order being number 113, Milord.
You are opposing? Yes.
Milord, kindly, Milord, comes to the operating part, Milord.
Order dated?
113, Milord. 113 portion of the 113 order.
Yes.
Milord, 2 orders have been passed. Milord, the second part I am challenging, Milord.
What is the second part?
Milord, by the second part, Milord, kindly, Milord, sees the ordering portion. The present prayer for the defendant, I am the defendant, Milord. The present prayer for the defendant under order 6, Rule 17 of the CPC for amendment of WS allowed with the cost of ₹600.
So how can it be agreed by your...
The next part. Then, Milord, the next part. Next, Milord, kindly, Milord, sees fix on 9th of April 2025 for amended copy of WS payment of cost by the defendant. Kindly, Milord, sees.
So
affidavit
you will not
no. Kind sees the next word, Milord. Affidavit in reply, if any, by the plaintiff against the amended WS. Affidavit in reply by the plaintiff against the amended WS.
Cannot be done.
Milord, how? Next, Milord, kindly, Milord, sees next order.
What does Order 8, Rule 9 say?
That is additional and subsequent event.
Yes.
Subsequent. No. Order 8, Rule 9, Milord, that applies for me, not for the plaintiff. Plaintiff is given liberty to file affidavit in reply against the amended WS.
Do you have a decision that applies only to the defendants? Order 8, Rule 9.
That I need to check.
There is a judgment of the coordinate bench which says plaintiff can also file.
Next, Milord, kindly, Milord, comes to the next order.
Have you checked up that judgment?
But Milord, kindly, Milord, sees the next order, Milord. Kindly, Milord, sees the next order.
Yes.
114, Milord. Kindly, sees the operating part, Milord, 2 lines above that.
114?
114, Milord.
Yes.
2 lines above the operating part. No affidavit in reply has been filed by the plaintiffs today. No prayer for time to file the same has been made. Plaintiffs are thus debarred from filing affidavit in reply against the amended WS.
So you have
has been debarred. Now, Milord, kindly sees the order number 116.
Yes.
Without challenging that order, my lord, court is allowing upon payment of cost. 116, my lord, kindly my lord sees the last order, last page. It is, however, to be noted, plaintiffs have not furnished any plausible explanation as to why they failed to submit the rejoinder to amended WS on 9th of April 2025, despite being their specific direction for the same. Accordingly, prayer for acceptance of rejoinder to amended WS should be allowed, but with cost of rupees 600 to be paid by the to the defendant positively on the next date. Hence, it is ordered the instant petition of the plaintiff praying for acceptance of rejoinder to WS if hereby considered allowed with the cost of rupees 600 million.
The issue that arises for consideration is whether a
Lord, this is my matter, my lord.
Yes.
But I have come in the peculiar circumstances.
Yes.
My lord, and under Order 18, Rule 2(1), your lordship knows, my lord, that after the evidence given by the plaintiff, the defendant will give evidence. What the learned court has said, after the closure of the plaintiff's case, that you are not entitled to give evidence in spite of my prayer, and said that you will have to give the argument, start your argument. My lord, can you look at the page, last page? Well, I cannot. What argument I will make unless I give the evidence, my lord?
No, your evidence has been concluded.
My evidence has been concluded. How, my lord? I have not been allowed to give evidence.
No.
My lord, can we read?
Please kindly come to that. It's the recording.
Wait for adducing evidence.
On perusal of the record, it transpires that the evidence of both parties were completed.
But that is an earlier stage when the plaintiff had died. Thereafter, new plaintiff came to establish her right as owner.
Yes.
And that she could not establish her owner. She gave evidence, but could not establish
Show me
owner.
that order. Show me that order.
But 109, Lord, at page 41, 45 to 46, Lord, 47. Kindly look at Lord, that order.
Page
45 to 47 at the relevant page 46. Kindly look at me. That is the reason why, my lord. Nothing other than that. How the after new plaintiff came. My lord, obviously, my lord. Obviously, has your lordship got it, my lord? Right of the plaintiff has been extinguished with her death, as she was holding life interest, but the application will not be applied in this suit, as this is a suit for eviction of a monthly tenant. It is to be ascertained whether the right to collect rent from the defendants continued or not. Then it will be held that right to sue survives. In this case, it is contended by the original plaintiff that on her consent, the pro forma defendant was collecting rent from the present defendant, or after her death, with the strength of the probated will executed by Khetra Mohan Kaur, the petitioner has become the landlord owner in respect of the suit premises against the defendant, but that has to be established by adducing evidence by the petitioner. So, my lord, on that basis, my lord, she wanted to give evidence. She gave evidence. I filed the written statement. Written statement.
Did I have the occasion to deal with this matter?
Yes, my lord. That is the reason I, my lord, will kindly look at page number 104 to 106. Earlier order, where the husband wanted to give evidence, and your lordship said, yes, certainly husband can give evidence. My lord will kindly show that the order dated 25th.
Page 103.
Lord, 103, but my lord, the relevant part, kindly look at page 105. Kindly look at it, Lord. Page 105. Par contra, Mr. Chakraborty, that is the counsel appearing for the transposed plaintiff,
herein submit that suit is at the stage of argument. The order being number 109 dated 16th
No,
November.
initially, let me the parties have laid their respective evidence.
Earlier.
Well, thereafter, the plaintiff or the landlord died. So the subsequent, the substituted heirs have come in.
Substitute, not heirs. That is the order 1, rule 10.
All right. So
She is a new person.
Yes. So the evidence was directed to be laid only to prove the limited extent of the ownership.
Not only ownership, but I have a
did you cross-examine that PW1?
Yes.
After that, where is the scope of leading further evidence?
The scope is, there is judgment I have.
Yes.
And kindly,
after it will be again a roundabout way. What evidence? Other issues.
I will only say in my evidence that he is not the owner, nothing else.
That is, sir, that is in the cross-examination, you can make that suggestions. Show me your
state, but he denied. All right, he said, no, I am the owner. Now, I want to say, by producing documents that she is not the owner.
Show me the cross-examination of PW1.
Yes,
show me the cross-examination of PW1.
Well, at page, starting from page, we'll kindly look at one page. May I show to your lordship? Well, we'll kindly give you 1 moment's time. Well, one of the page, Willard, is at page 133.
133.
Well, relevant part, my lord, will kindly look at. I cannot recollect whether the leave of the court was obtained after my wife transposed to the position of the plaintiff for adopting the statements made by my mother. I cannot recollect whether plaint was amended incorporating the requirement of my wife or not. I cannot recollect whether the statement of my wife as plaintiff of the suit have been incorporated in the plaint or not. I do not know the law properly, but I only know that after my demise of my mother, my wife became the owner of the property. But these are the statements in the cross-examination. So therefore, my lord, I have a right to show.
Why did not put this your essential case in the cross-examination?
I have.
Show me that with regard to the ownership, I have challenged that.
Yes, I have, my lord.
Show me.
Kindly give me 1 moment's time.
Yes, the suit was fixed for argument. What happened on 16th of July?
The 16th of July, the date I prayed for, allowing me the evidence in terms of my written statement wherein I said that plaintiff is not the owner, neither the landlord, because the substituted plaintiff who has newly come de novo, she cannot be, but the heirs of the original plaintiff are the owners. That part has been rejected to be considered. But that is the only, but I have nothing to extra say. I will only say, my lord, in my evidence that she is not the owner.
That is your original evidence. Please bring that original evidence in the suit.
Original suit, my lord.
Yes.
But in the original evidence, my lord will kindly, my lord, consider. This aspect is there that so far Shefali Kaur is concerned, the original plaintiff was not even the owner of the property.
So in
Somebody
the
else
matter,
is the owner.
so if that is your evidence, there is no necessity of because you have denied the ownership of Shefali Kaur. So this person is claiming through Shefali Kaur.
But my lord, that has been denied by them.
No.
At that particular point of time, Shefali Kaur,
they may have denied. But your case is that Shefali Kaur is not the owner. You have produced at that point of time evidences in support of that.
At that point of time, the documents were not there in my favor.
Why?
The document to
Sir, your case is that, your basic case is that Shefali Kaur is not the owner. These persons are claiming through Shefali Kaur. So,
not claiming, my stand corrected. But Shefali Kaur's
being the evidence of your original evidence in the suit?
Tomorrow, my lord.
Uh, when is the next date fixed?
The next date fixed is 1st August. 1st August, my lord.
1st of August. Yes, I'm keeping it Monday. You serve a copy upon the learned advocate for the opposite party.
Well, before only thing, only my lord, I agree. In the meantime, my lord, they will not pass any order.
1st of August, you have said next.
But
So I'm
my lord,
keeping it in the next Monday. The petitioner is direct. Yes.
For the petitioner, my lord. This is a section 24 application, my lord.
Come at 2 p.m. Section 24. CPC.
CPC, my lord.
For want of determination, let the matter go out of. ঠিক আছে?
defendant petitioner lawsuit.
Yes.
Suit for declaration and injunction. Admittedly, suit posted for argument. At this stage, defendant filed an application for amendment of the
Posted for argument.
file an application for amendment of the written statement. The one of the judgment order passed by the BLR, that copy of this order was not produced at that relevant point of time due to mistake due to non-found of this document at the point of time. So they prayed for an amendment of the to that extent. Learned trial judge rejected the application on the ground of provided clause. Impugn order dated lawsuit 3rd June 2025. My amendment application lawsuit, page 34.
Page
34. 34. And schedule of the amendment, page 35 lawsuit.
This is an order of 1993
lawsuit.
Yes, suit was filed in 2010.
Suit
is of 2010.
2018.
2018, yes.
Yes, that document was not actually not found at the point of time lawsuit. So that they are not
a defense case.
My defense case, my predecessor is the owner of this lawsuit, original plain lawsuit, page.
No, you are the defendant.
Yes.
What was your defense case?
Defense case is that my predecessor name was duly recorded in the ELA record of right as well as Mat Khosla as a owner, and another defendant's name was recorded as a Borgata.
Yes.
That was only that document. That proceeding was initiated the BLRO, and that proceeding was disposed of by holding that my predecessor was the owner and the director, the Borgata, to produce the.
Show me your case made out in the written statement.
Written statement lawsuit, written statement, original written statement, page 19 lawsuit, 19, paragraph 11 lawsuit. Relevant paragraph lawsuit, paragraph 11, page number 23 lawsuit. That the real state of affairs in this, the entire suit for property originally belongs to the predecessor interest of this document, namely Abdullah Mullah, my predecessor lawsuit. And another person is Moinullah, alias Moni Mandal, whose name was, there is a Borgada, recorded in the.
Where it has been recorded as Borgada.
That was not stated here.
So,
but
no, in the original written statement, what was your case made out?
That
both of you are the owners.
Abdullah Mullah and another name was Munir Mullah, whose name was recorded in the ELA record of right.
As?
Nothing, that was not stated lawsuit. They used to possession the entire suit property since the year 1357 BS. Concerning their long position, their name were recorded at the time of Mat Khosla. That during the said joint position, Abdullah and Muni, no partition held in between them. And this order was lawsuit
BLRO initiated a proceeding and that was disposed of. So the only to that extent, only bringing the order, only order. They in the ordering process, in the order there was that the Abdullah Mullah is the owner and Moniullah Mondal, son of Jakir Mullah, directed to deliver the bhag produce in favor of the landlord Abdullah Mullah. In the order, it was reflected that Abdullah Mullah is the owner and the Moniullah Mullah is the tenant, Borgadar.
Who is the plaintiff?
Plaintiff, the separate persons, they are claiming by way of deed. I also challenge that deed. The deed was not your lordship. They are the son of lordship. Manik
Abdullah Mullah. Abdullah Mullah is the father of the defendants.
Abdullah Mullah is the father of the defendant.
Yes. And Manullah Mondol,
defendant plaintiff is the Fojul,
yes,
son of late Yat Ali Sheikh.
Yes, so this has nothing. This order has nothing to do with the plaintiff.
The plaintiff is nothing to the plaintiff, but the defendant defendant proved that their ownership lordship. The for
Yes.
Judgment data, plenty will get system before your lordship. In an ejectment suit, I got a degree. Now, your lordship, I put that degree in execution. Police self was allowed. Thereafter, in 99, an application was filed by the opposite party's predecessor that he has an independent right
Order
to the
21,
judgment data.
Order 21, Rule 99.
99 read with 101. Now that for 26 years that proceeding is pending, your lordship, and one after another delay is being caused. Substitution petition was allowed. He was told to take steps for correction, did not take. Thereafter, show cause has been.
Who was directed to show cause?
The petitioner in the Mitch case. That is the person who has.
Application under article. So
For-
you are Yes. Yes.
My lord, this is an application, my lord, challenging an order dated 19th May 2025, wherein, my lord, on March 10, 2025, the petitioner father has filed an application under section 151 for seeking the one-night custody of the half side of the vacation of the minor child who is 6 years old, my lord. That application has been partially allowed by an order dated, my lord, 19th May. My lord, kindly come to the ordering portion. That is
summer vacation. Summer vacation is over now. Puja vacation is coming.
my lord, subsequently, not only for summer vacation and for the further vacation, my lord. My lord, not only the application, but not only for summer vacation, but further vacation. My lord, kindly come to the second
10th of September has been fixed for what? For hearing of what?
My lord, the main application, my lord. My lord, my interim application has been rejected, my lord. Kindly come to the second last page of the order, my lord.
considering
In the summer vacation, you had the access with the child for this period.
no, my lord. My lord, only the ordering portion, my lord. Only the day, my lord. The petition has prayed the half port side of the vacation to be stayed with the child to be stayed with the father. In spite of allowing that prayer, my lord, the learned court has allowed only the 2 days, so 2 alternate days from 11
That
p.m. to
was
6.
done.
That was done, my
complied
lord.
with.
That was complied with, my lord. But
The petitioner.
for 26.
None appears for the petitioner at the time of.
That he is appearing on.
Since I'm not inclined to take up this matter on personal ground, this papers be placed before the Honorable Chief Justice for necessary orders. Next.
I'm obliged.
Item number 28.
May I please, my lords?
Yes.
But may I file my affidavit of service, my lord? There is a caveat filed by opposite party number 1. My lord, the question before my lords, my lord, the petitioners
Yes.
are defendants, some of the defendants in a suit, my lord, filed by opposite party number 1, my lord.
I'm appearing on the basis of seeing the cost title. Well, I'm appearing on the basis of seeing the cost title.
No, yes, served.
No, my lord, I am defendant number 18. This is, my lord, arising out of a suit for partition. I am defendant number 18 and I have a counterclaim, my lord, in that suit. My lord, I am opposing this petition. My lord, the next date in the trial court is on the 19th of November. My lord, kindly make it not today. Let them give me a copy, my lord. We can argue it and finish it off tomorrow.
My lord, with the greatest of respect, my lord, my learned friend doesn't have any right. Lordship will kindly permit me, my lord, the checkered history, my lord, if I may use the term, my lord.
What is the impugned order?
Impugned order, my lord, what had happened? A suit for partition and declaration filed by, my lord, the plaintiff, claiming that his father's HUF is not yet partitioned. He seeks partition. I am one of the brother, my lord. Petitioner is one of the brother. In that, my lord, I file an application under Order 7, Rule 11, saying that there already was a partition effected between the parties, between all the parties by way of a registered instrument, my lord. So there is no cause of action, hopelessly barred by law, and more than that, my lord, I even submitted that the suit, though valued at 10 crore rupees, the court fees was paid 100 rupees only. So, my lord, I took all these points, saying that, my lord, the suit deserves to be nipped in the bud. My lord, thereafter, my lord, the plaintiff takes out an application under Order 6, Rule 70. My lord, a plaint which otherwise, my lord, originally is of 14 page, an amendment application of 18 page, running into 18 pages, schedule of amendment 18 pages. Now, my lord, by the amendment, the plaintiff seeks to change and convert the partition suit into a declaratory suit. There, my lord, he says that a declaration signed by him in the year 2009 is null and void. in the year 2024. Deed of partition registered in the year 2008 is null and void because it was given a go by, and my lord, that is allowed. So by the impugned order, my lord, my order 7 rule 11 has been rejected. Order 6 rule 17 has been allowed. So this is the impugned order. And how, my lord, the learned court was dealing with the matter, my lord, I will just. Matter was, my lord, originally fixed, my lord, if lordship takes third volume, my lord. If my lord kindly takes third volume, page 559. My lord, before impugned order, my lord, if I may trouble your lordships, with page 559.
Where is the plaint?
Plaint, my lord, starts at page, first volume, my lord, page 163.
163.
163, my lord, first volume.
Yes.
My lord will kindly see what is the plaint, what is the prayer. Plaint starts at page 163. If my lord kindly sees the nomenclature of the plaint at page 166. Suit for partition, accounts and perpetual injunction valued at rupees 10 crore and rupees 100 only. Rupees 10 crore for the suit and rupees 100 for application for injunction. And court fees of rupees 100 is paid only, my lord, on this suit. Rupees 100. Court entertains such plaint, my lord. Now, the prayer lordship will find at page 181, my lord. Prayer starts at page 181. My lord, before that, if my lord kindly turns the cause of action, paragraph 26 at page 178, once, my lord. Page 178, paragraph 26, 26, my lord. That the cause of action of the present suit is not barred inasmuch as, my lord will kindly see. First of all, no date is mentioned. Inasmuch as the defendant number 1, my lord, who is the petitioner before your lordship, has wrongfully let out portions of Mumbai property. So, my lord, the entire dispute is with regard to Mumbai property is being agitated in before a learned court at Alipur. Situated as so and is wrongfully collecting the rentals in his sole name, and further the defendant number so, and my lord will kindly see last line of that paragraph. By wrongly stating to the intending buyers as if partition has already taken place. So, my lord, if there is any cause of action, my lord, for the plaintiff, it's a specific case of his, my lord, that no partition has ever taken place. So, my lord, if there's no partition, my lord, he needs to proceed on that basis. But how now, my lord, I put a question to myself. By way of amendment, he says that no, and there's, my lord, lordship can take it from me, not an iota of word about the declaration or the deed of partition, my lord, which was executed, signed by this very plaintiff, my lord, in the suit.
Where is the application for amendment?
Application for amendment, my lord, starts at third volume, my lord, page 422. Third volume, page 422, my lord.
Can I share a brief?
You to already must be. He's there, my lord. I have served it to Mr. Devra, my lord. My lord, lordship will kindly.
422, yes.
422, my lord. Page 422 is the application, my lord, and the schedule of amendment starts at page 439. Lordship will kindly see what is the amendment sought. Page 439. And my lord will kindly see. Page 439 onwards. 439, 440, 441, 42, 43, 44, 45, 46, 51. And my lords will find the additional praise starting at page 453, my lord. My lord, a completely new suit, my lord, has been, my lord, allowed to be, my lord, surface on the file of the learned court, my lords.
वकालत नामा फाइल कैफियत आपका लिखे ना लिस्ट आपको बनाना चाहिए
When the partition deed was registered,
It was presented for registration in the year 2008.
when it was registered.
My lord, registration completed in the year 2023 because of payment of stamp deficits, stamp duty, my lord.
Yes.
After the suit was filed, he took steps.
Sir, please, you have sought for time, you said you have not got the copy.
No, but I know
Will
the
be-
case. I'm appearing before the trial, but I'm sorry.
My defendant never appeared before trial court. He never appeared. Trial court, he did. Oh, sorry, I stand correct. I stand correct.
When the amendment was sought for?
My lord, after I filed my order 7 rule 11, my lord.
No, no, one, I want
The-
to.
The date, my lord.
Yes.
My lord, will kindly bear with me for a minute, my lord.
Eighth of January 2024.
My lords. It
So it was registered in 2023.
Two.
So, no, the partition deed.
Partition.
So in 2024, he has applied for challenging that partition deed. He could not have done it prior to that.
My lord,
Could not have done it prior to that. This is a subsequent event, sir.
he seeks challenge to 3 documents, my lord. One is a declaration of 2009, which was always there. My lord, that he could not have in the year 2000, because, my lord,
What is the declaration for what?
my lord, where he declares, the plaintiff declares that the Mumbai property is my exclusive property. That is his declaration. My lord, that is the declaration affirmed before the learned Metropolitan Magistrate at Calcutta way back in the year 2009, my lord.
What is that document? Show me.
Page 140, page 145, my lord.
Yes.
My lord, deed of declaration, lordship will see. This was always in existence, my lord. Page 145. At page 147, my lord will see the 5th person, my lord, is the plaintiff, Manoj Kumar Ganeriwala. My lord, Savitri Devi is my mother, my lord. 2, Pradeep Kumar Ganeriwala is your petitioner, lordships. And my lord, others are my brother. If my lord, in this declaration, if my lord straight away turns to page 150, internal page 5, my lord, I will not trouble your lordship.
Yes.
Paragraph 6, my lord.
Yes.
We do hereby confirm, everyone is confirming, my lords, accept, agree, declare and ratify that we had not and we do not have any objection to the mutation of the name of Pradeep Kumar Ganeriwala HUF being recorded in the various offices under the Collector of Mumbai, Mumbai Municipal Records and also records of City Survey Office and all other concerned records as being, my lord will kindly mark this, as being the absolute owner of the said property, as being the absolute owner of the said property.
What is the basis of this absolute owner declaration?
My lord,
What
family
is the-
settlement, family settlement. My lord, this,
Where is that family
that
settlement?
2008 deed, my lord,
So partition deed.
partition deed.
That has been registered in 2023, sir.
My lord, it was placed before the registering authority in the
Maybe.
year 2008.
Sir, unless it is registered, cause of action does not arise.
My lord, that can, my lord, with greatest,
Cause of action does not arise.
my lord, then, my lord, if I as a plaintiff, my lord, I approach a court,
Sir, if the registration is rejected, what will happen?
my lord, with the greatest of respect, my lord, there cannot be rejection. It can be impounding of, my lord, subject to correction, my lord. There can be impounding of document and, my lord, the learned registry, my lord, can direct, my lord, the parties, my lord, to put in the deficit stamp duty along with, my lord, penalty, my
So
lord.
that is the difference. Unless it is registered,
My lord,
once it is registered, it will take effect from that date. Unless it is registered, so it has been registered in 2023. So point of limitation is a disputed
my lord, I could
question
have,
of the
my
fact.
lord,
It will be decided
my
at the
lord
time
will
of suit.
kindly, my lord will kindly take this, lordship will kindly turn.
And
to
that affidavit declaration has its basis in the partition date, which was
My lord, will
executed
kindly
in
take page,
2008 and registered in
my lord will
2023.
kindly take page 178, my lord.
Yes.
The plaint, my lord. What he says, my lord. Last line, my lord, at page 178. Last line, paragraph. by wrongly, my lord will kindly see, stating to the intending buyers as if the partition has already taken place. So, my lord, this is the specific case, my lord. It is not his case, my lord, where he says. Paragraph 26, my lord. Paragraph 26.
Yes.
The cause of action, where he pleads cause of action.
Yes.
Please, one second. Please, one second. That the cause of action of the present suit is not barred in as much as so and so, my lord. Then last line, my lord. I'll straight, lordship will kindly come to last. By wrongly, my lord has got it, my lord. Last line, my lord. By wrongly.
Yes.
By wrongly stating to the intending buyers as if the partition has already taken place.
Yes.
My lord, there is not an iota of word, my lord, in the entirety of the plaint that we executed a document, but it has not been, my lord, completed. I executed a declaration, my lord, but then that is not binding on me. My lord, lordship will see. Lordship kindly permits me to place the plaint. If thereafter, if my lord thinks, my lord, that there is no, my lord, a right which otherwise accrued in my favor is being trying to be snatched by way of
That will be decided, sir, in the suit. That will be decided in the suit. So amendment has been sought for. That has been allowed. Your submission is that it's a document. Partition deed is being challenged for the first time in the year 2024. When it's a document of 2008, it's barred by law. But fact remains, registration was completed in 2020.
My lord will
and in January 2024, the
my lord will kindly take section 47 once of registration act.
Section 47, sir, I'm aware. Once it's registered, it relates back to the date of execution. I'm aware of those provisions. So it's not that. But the registration is 2023. So how can a person challenge in 2008 when the registration is completed?
My lord, the document always, my lord, subsisted. It existed, my lord, in before the registering authority.
All right. Yes.
My lord will kindly.
For that, you did not cite section 47. I am aware of.
So, my lord, what I am on, my lord, a document which otherwise was signed. I could have understood, my lord, that there was a pleading in the original plaint saying that we signed, but then we do not agree to it. There is not an iota of word. My lord will kindly say on what premise.
So partition takes effect by a decree of the court or by a registered deed. So execution of our deed for partition, unless it's registered, cannot affect partition.
My lord.
So registration completed in 2023. But do you mean to suggest, since it was executed in 2008, party has to challenge in within 3 years of 2008?
No, my lord, I am not on that, my lord. I am not on that, my lord. What I am on, my lord, is that a partition suit now is being completely transformed into a declaratory suit. That cannot be permitted.
Sir, in every suit for partition, declaration is built in such a suit.
My lord, declaration to what extent, my lord? Lordship, I put a question to myself. Declaration to what extent? Declaration means that I am 1/5, 1/10, 1/11, whatever owner. My lord, that declaration, my lord, I am, because that declaration is seized. Lordship will kindly see the praise.
Sir, if a document, according to you, according to the plaintiffs, it's an unpartitioned property. So they have sought for partition. According to you, yes, it was partitioned by a registered deed. So unless that cancellation is sought for, so they have a right to seek for cancellation. It will be decided whether the cancellation will be granted or not. That will be decided in the suit.
My lord, what I am on, my lord,
amendment does not decide the rights of the parties.
Definitely. No, it my lord, here in this case, my lord, it has taken away the right which accrued in my.
No. Sir, it's only challenging. Unless that is set aside, it cannot take away your right.
No, my lord, I am not on that. I am not on. My lord, there was a clear admission on the part of the plaintiff where plaint proceeds on the premise, my lord, that no partition ever took place.
Yes.
It is an admission.
Yes.
Now, by way of this amendment, my lord, he has been permitted.
He's not admitting, sir. He's challenging that. So where's the question of admission? He's challenging that. His initial case was that the suit property is an undivided property. You are trying to make out a case, no, it's a divided property because this is the registered deed. That is, he's maintaining that admission, it's undivided. That's the cause of action for challenging.
My lord, now my lord will kindly, lordship will kindly hear me for 5 more minutes, my lord. If thereafter, my lord, if I am unable to satisfy lordship, my lord, I'll rest my case. If my lord kindly takes CPC, my lord, order 7 rule, lordship will kindly permit me to place 7 rule 11.
Yes.
What are the grounds, my lord, on which a plaint needs to be rejected?
So there are 2 things. First is amendment.
My lord,
so
impugned order both. My lord, impugned order takes care of both. Oh, sorry.
When the 2 applications are filed, Order 7 Rule 11 and Order 6 Rule 17, court has to decide first the Order 6 Rule 17. That's the well-settled proposition.
My lord,
so, yes. So now you have to proceed. There are 2 things. If you challenge Order 6 Rule 17, you cannot now straight away go to Order 7 Rule 11. Now, when you want to proceed with order 7 rule 11, you have to accept the amendment. Then you can make out your case under order 7. So you are now accepting order 6 rule 17 amendment. Then you are trying to say even after amendment, the plaint can be rejected. Yes. Yes, which provision of order 7 rule 11?
My lord,
Which clause?
Subclause C, my lord.
Yes. Yes, show me that the court has required the plaintiff to put in the deficit court fee.
My lord, that
Show
is
me
the
that
error.
the
My lord,
court
that is the error which is there, my lord, in the imputed order.
This is order 7 rule 11. In order to invoke order 7 rule 11C, there are two stages. First, the court has to come to a finding that the suit has been improperly valued, and this is the deficit court fee. So court, after coming to that finding, has to require the plaintiff to put in the deficit court fees within such and such time. On failure of that, cause of action under order 7 rule 11C arises. Show me these two things, that the court has arrived at a finding that the suit has been improperly valued, and what's the deficit court fee.
My lord, will kindly see how the suit has been valued.
Sir, show me. Show me the decision of the court that court has said yes, it's improperly valued, and this is the deficit court fee. Because if you please finally come to order 7 rule 11C, please read order 7 rule 11C.
Where the relief claimed is properly valued. So, my lord, my case is here relief claimed. My lord, I assume, my lord, that the relief claimed is properly valued. But the plaint is written upon paper insufficiently stand. My lord, this was my case. This was a specific case in order 7 rule 11.
Yes.
That the plaintiff.
Then proceed thereafter.
And the plaintiff, on being required by the court to supply the requisite court stamp paper.
This direction was there.
My lord, that is what I am. My lord, that is why, my lord, I am challenging. That is also one of
Come
my
to the order that he was being required to put in this.
My lord, court did not. My lord, the learned
That
court
is,
did
sir,
not.
that is why I am telling you. So there is a stage prior to order 7 rule 11C. Court has to first come to a finding. Yes, this is the valuation is improper. Court fees is improper. This is the deficit. Court has to direct the plaintiff to put in that. Show me that order.
My lord will kindly take the impugned order once, my lord.
Yes. It cannot be by the impugned order. It has to be anything prior to that. Because they have to be, sir, let us come to, the court comes to a finding that yes, the suit has been improperly valued. So they are required to put in 30,000 more as court fees. Now the court has to direct them to, yes, please put in 30,000 within 2 weeks or 3 weeks. Now, if within that time they fail, then the cause of action under order 7 rule 11C arises. So before that, you have to show that court has.
No, before that, my lord.
So if it is not that, order 7 rule 11C does not stand attracted.
And my lord, my
first
last.
Yes, now you are trying to show the valuation. Yes, please show me the, according to you, the adequate court fees was not paid.
No, my lord.
So this is a suit for partition.
Suit for partition.
So suit for partition, how it is to be valued?
My lord, section 7, my lord, of West Bengal Court Fees Act.
It's ad valorem or fixed court fee.
My lord, if they are, my lord, in my respectful submission, if they are not in possession, it has to be, my lord, on the basis of valuation. My lord, kindly promise. My lord, section 7, my lord.
In the plain, they have admitted they are not in possession.
Yes. I will
show me. Show me that they have admitted that they are not in possession. Show me the case of ouster made in the plain and they have sought for recovery of possession.
My lord, paragraph number 7, my lord, of plaint at page 169, my lord.
Yes.
That the defendant number 1 by taking, my lord, that is the petitioner before your lordships. Sorry, my lord, page 169. 169. 169. Paragraph number 7.
Yes.
That the defendant number 1 taking undue advantage of his position as Karta of the said HUF is hurriedly trying to dispose of and or convert for his own personal use such immovable properties of the HUF by selling and or renting off in his personal name, and as such other properties which are outside Kolkata as the same are not, lordship will kindly mark this, as the same which are not physically occupied by other members. Clear admission. He admits he's not in occupation. Other members of the HUF. He clearly admits that I am in occupation. He admits that the property is in my name.
Yes.
Detriment. My lord, paragraph 8 also again. That the defendant number 1 taking undue advantage of his name having been recorded as Karta of so and so with active assistance of his 2 sons so and so is regularly converting the investments in shares and securities. So he admits that even there he is not in possession of those shares and demat account also. He admits that I am in possession. I am my lord, as per him, my lord, I am siphoning it off.
Yes.
9 also, my lord.
Yes.
I am collecting huge rent in my personal name all throughout, my lord. The defendant number has, my lord, paragraph 10. The defendant number 1 has managed to get mutated Mumbai property situated in his own name. My lord, this property was mutated in my name pursuant to an honorable division bench order passed by this court, my lord, way back in the year 1996. Now, my lord, now lordship will kindly permit me to place section 7, subsection 8, my lord, for partition and separate possession. Lordship, 7.
Yes.
For partition and separate possession of share of joint family property in suits for partition and separate possession of a share of joint family property or of a joint property, or to enforce a right to a share in any property on the ground that it is a joint family property or joint property if the plaintiff has been excluded from possession of the property of which he claims to be a co-parsoner or co-owner according to the market value of the share in respect of suit which is instituted, my lord. My lord.
Have you taken steps under section 11 of the Act?
My lord, I took that point in my order 7 rule 11.
Cannot be.
I did not file a separate application under section.
Sir, cannot be because this inquiry into the valuation, section 11.
Section 11
That's
is
the
the inquiry.
procedure.
That is the
So
procedure.
that you have not taken any
Paragraph
steps.
22, that pleading was only with respect to a property in Bombay. Paragraph 22, I say I'm in possession of one of the properties. Cause title plaintiff shows he is residing at one of the suit properties.
Section 11, you have to take steps. Apply under section 11. The court, let the court decide on the issue of valuation. If the court decides on the issue of valuation, directs them to put in the court fees, they fail, you can apply under order 7 to 11.
My lord, one more last submission, my lord, I'd like to make. My lord, I was not given an opportunity to give rebuttal
of
to the application. If my lord kindly
order 6 rule 17.
Order 6 rule
So
17.
that's the best point.
My lord will kindly take the order sheets at page 559, my lord.
Yes, Mr. Banerjee.
559.
That is correct. Then
It was for us to give a reply to his submissions. He had concluded.
Says that he did not.
The order sheet will show that's not correct.
I will show.
Order sheet will. My juniors were also appearing. Anyways, the order sheet will show he was also appearing. It was for us to give a reply to his submissions.
No, but
and we just
that's
gave a
oral submission. But according to him, he was not given
reply. No pleadings.
No, written objection he filed.
Yes.
No, I filed written.
Written
objection filed. Written objection I filed.
Then
it was at the stage of arguments, my lord. My lord will kindly take.
No. So you said that you did not get any opportunity to
give my reply to the submissions made by the plaintiff.
So on what point? I will decide that. Please make your submissions now here. On what point of rebuttal? What rebuttal you want? I was under the impression that you were not given opportunity to file written objection.
No, I filed written objection.
So you made all points. So,
my lord, I'll just tell your lordship what had happened. The history of this particular matter, my lord, and the learned presiding officer was hearing the. My lord, I had taken out an application under section 24, my lord, seeking transfer, my lord. Because
that's a different thing altogether.
My lord will kindly wait. My lord, this matter was last argued and heard before the learned court. My lord, if my lord kindly takes page 559 once, my lord. Page 559 once, my lord.
Yes.
On 14th of February 2025, my lord. If my lord will kindly see, that day, my lord, no hearing could take place. If my lord kindly takes 5 lines from the bottom because of the local bar resolution. 14th of February. 559, lordship. In order, 14th of February, my lord. Due to, if lordship takes 6 lines from the bottom, due to resolution of local bar, case is urgent. My lord, and if my lord kindly takes first line of this order, today is fixed for reply of submission of the defendants in respect to the petition dated so and so. My lord, this was fixed for my.
28 June is for amendment. 28 June 2023 is the petition for amendment.
No, 28 June is, my lord, my
Order 7 Rule 11.
Order 7 Rule 11. And there is this 8th of January, my lord. So those both the applications were being heard simultaneously.
Yes, yes.
Thereafter, my lord, the matter was taken on 10th 4th, my lord. My lord, this particular learned judge, my lord, was already under order of transfer, my lord. And my lord, I have pleaded in my petition, my lord, that she was not holding court, my lord. Now, my lord, will kindly see what happened. Today is fixed for reply.
No, what is your allegation?
My lord, matter was not heard and order has been passed. She was not sitting. She was not, my lord, hearing any matters. My lord, I have specifically pleaded. If my lord kindly takes paragraph 31 of my petition once. She was not attending court, my lord. She was not holding court, sorry, my lord. Because she was under order of transfer.
Maybe she was under an order of
This
transfer.
matter was, she did not hear it completely, my lord, and this order has been passed. My lord will kindly, lordship will kindly remit it back. Let the learned presiding officer re-hear it.
What's the wrong in that order? What's the wrong in that order?
Self-contradictory order. My lord, self-contradictory order, my lord. I have not been given an opportunity.
No,
my lord.
that's unfair, my lord. Lordship will have a look at 554. It was for my reply to a submission of the defendant. Which I have a lot of respect for him, my lord. He would not do this. 554 is 20th of July 2024.
Correct.
Third last line. Heard both parties in full. Lordship will turn over to 555. Last, my lord, third paragraph. Another application has been filed on behalf of the plaintiff, praying for an opportunity to reply and rebut and respond to the submissions made by the defendants one so and so, being the on 20th July being the last date fixed in the matter for hearing the application filed by defendants on the ground, and the last date after completion of submission on behalf of defendant number 1. Court fixed on 28th August for reply on behalf of
August 2024. And this order is passed on April 2025.
He objected. He records that.
I do say that
my reply to his submission, he objected. That the court held no, for the ends of justice, I will give the plaintiff a chance to respond to what you have argued on 20th of July, which is here 554.
Lordship will kindly take order of 14th.
Then we say that the court is not going to give the resolutions. All these orders are there, my lord. It's unfair on the learned trial judge to say she closed it without giving us a hearing. Then as plaintiffs, we said that we don't want to waste any further time. It's all recorded. In fact, at 555, your lordship will find learned advocate for the defendant numbers 1, 5, 6 and 13, last sentence, has raised objection to the prayer of the plaintiff to accord him an opportunity to reply. He had concluded. I wanted an opportunity to reply. That opportunity was given to him despite objection.
My learned friends was given an opportunity.
Mr. Banerjee, please turn over to the next page. It says 13th of September 2025 for reply to the submissions of the
defendant. Correct.
That's by the plaintiff.
That's right.
Because my lord, the plaintiff.
And when we don't make that argument, we just give a written note.
Exactly, my lord. My lord, written notes is filed, my lord, and I am not given an opportunity to rebut.
Controvert. So where is the law to it? Controvert. So another.
My lord, on the basis of notes of argument, my lord, I will not be given a note. My lord, it is not, because my lord, they try to make up a new case, my lord, in written notes of. Lordship will kindly see the order sheet also says so. Written notes, not stuff.
What is it doing? All right, sir. I will not consider their written notes. So this is all. This is the application and the written objection. I will not consider anything in the written notes. So the 2 points. One is, it's according to you, it's barred by limitation. Second is valuation. These are the 2 points which you have raised.
No, my lord, and fresh cause of action. By amendment, fresh cause of action has been
given. Yes. So
lease of life has been given to the suit, my lord. This, which completely changes the nature and complexion of the suit. My lord, if my lord kindly permits me to place 2 judgments, my lord.
For what proposition?
Lord, with regard to Order 6, Rule 17, my lord, on what ground, my lord, Order 6, Rule 17, my lord, may be permitted, my lord. Lordships are aware, my lord, 2009, Volume 10, SCC, 84.
This was considered in 2022 16 SCC. Please show me that. This was considered in 2022 16 SCC, page 1. Mr. Banerjee, have you brought that? That's the latest decision. Paragraph 71
compendium
called out all the on what this way, that way, everything. Yes, which paragraph you are trying to rely upon?
So the factors, last paragraph, my lord. Factors to be taken, my lord. Paragraph 63, my lords. Last
63.
page, my lord, last page of this judgment, my lord, I will not trouble your lordship with the other part. Last, factors to be taken into consideration.
Yes, which clause you are trying to rely upon?
Whether the amendment sought is imperative, my lord, in my respectful submission, it
That's
is not.
me.
My lord,
That's the guiding factor. If not, no amendment.
my lord, the suit proceeds on the premise, my lord, that no partition has ever taken place. My lord, that is the premise, the whole premise of suit.
That I followed your argument.
So, my lord, in my respectful submission, my lord, it is not at all proper or imperative for the adjudication of the case, whether the application for amendment is
According to it's a malafide one.
my lord.
Yes, next, point number 3.
My lord, number 3, my
Should
lord.
not cause prejudice.
My
So
lord.
it causes prejudice because your case is that of a registered partition deed. If that is allowed, that
not
will
just
take away your right.
Registered partition deed, on top of that, my lord, partition already effected, property is distributed. Property is distributed.
Yes.
Hmm?
Yes, next. Fundamentally changes the nature and character. Partition suit converted to a declaratory suit. Next. Fresh suit on the amended claim is barred.
6.
So 2008 partition deed could not have been amended in
2009 declaration. 2009 declaration, my lord.
2009 declaration proceeds on 2008.
No, my lord, it does not say, not even an iota of word that it is on the basis of this, my lord. Lordship will kindly.
What's the basis of that?
My lord, time and again, my lord, they have been.
What's the basis of partition?
Family settlement, time and again.
Family settlement is in 2008.
No, my lord, there, before that also, my lord, there have been numerous family settlements. That was ultimate.
No, we are registered family settlement
No,
prior
that
to
was
that.
not registered.
So family settlement without registration is of no effect.
My lord,
It's of no effect. So that's the law.
but my lord, 2009 deed does not, my lord, speak of 2008 partition deed. Lordship will kindly.
Anything, show me where is the case made out that there was a
My lord,
registered
I am
family partition.
My lord, I am only relying on 2009 deed. Lordship will kindly independently look into 2009 deed. Once my lord will kindly permit me.
Yes.
If my
Yes,
lord,
Mr. Banerjee, what do you say?
2009, at least let that not be, my lord. Lordship will kindly.
That I
2009 deed.
two things, Munot. There's one order I'll just rely on. Firstly, Munot, your lordship will just have a look at
Sorry, one thing. You want to rely upon any other decision? Only
Okay.
2009.
2009 and one.
You want to rely upon, you can place that.
And lordship's judgment, my lord, though of course lordships have delivered it in a matter relating to written statement, amendment of written statement. Lord, paragraph 14, my lord, of your lordship's judgment. That apart in paragraph number 3 of the plaint, it was specifically stated that until termination of the tenancy of the opposite parties were joint tenants in respect of suit property. In the original written statement, there was only a vague denial of the same by the defendant. This court finds that by way of proposed amendment, the petitioner is trying to take out a new line of defense which is not permissible. My lord, by way of amendment, my lord, they are trying to bring in a new case altogether. My lord.
Yes. Yes, yes, Mr. Banerjee.
Only three things, Munot, that the suit was filed within April 2023. Within 3 months, I filed the amendment application. It does not.
The registration was made in 2020. No.
Not even that. Please have a look at page 324. I'll place one paragraph. I won't argue anymore.
Yes.
Page 324 is his application. I'll read it out, Munot.
324.
324. This your lordship will find at page.
What is that application?
Volume 2, his 711. He files this because this he himself admits the registration is not complete. An unregistered deed of so-called, it's a document. There would be no obligation in law to challenge it.
Paragraph?
Just that it's part of paragraph 7. It starts with the IGR being number. 26694 issued by the Office of ADS.
It is pertinent to mention it continues to retain the original IGR with him. Copy of the IGR issued by the registration of the original of which is lying with the defendant number 3 is annexed here to and marked with letter such and such.
No, just above that, You're just 4 lines from top of that page 6. Your petitioners were under the impression that the defendant number 3 had completed the registration by payment of deficit registration fees and stamp duty of the deed of partition. But after having come to know about the incidence of the petition suit, your petitioners tried to obtain a copy of the registered deed of partition. When the petitioners came to learn,
it is who? Petitioners are?
Petitioners are the 711 petitioners.
Yes, 15613. Oh.
Yes.
So according to them, this document was with the defendant number 3.
Defendant number 3 IGR, but if your lordship reads on, my lord. Petitioners were under the impression defendant number 3 had completed the registration by payment of deficit registration fees and stamp duty of the said deed of partition. But after having coming to know of the institution of suit, your petitioners tried to obtain a copy of the registered deed of partition.
So they took steps for putting in the deficit after the filing of the suit.
That's it. I don't need to argue anything. And based on the 2022 judgment, it does not change the nature and character of the suit. It is not belated. Admittedly, trial has not commenced.
And what is your submission with regard to that 2009 document? Yes, sir. Show me which page.
The
declaration. What is that page?
Page 145, my lord. First volume, page 145.
145.
This is disclosed for the first time in the 711.
My learned friend's client is a signatory.
No, he says you are the signatory.
So that is also my case. That's a product of forgery. We've not that document. I'll look at 145 minutes. I'm just arguing on instructions now. $145 the key disclosed for the first time along with 711. Yes, this my specific case is that he disclosed this for the first time with the 711.
Yes, but he disclosed this for the first time, but it contains your signature. You are a party to that. Where is his signature? What is his name?
Manoj Kumar Ganeriwala, my lord.
That's my case.
The signature is there.
Yes, my lord. Lordship will kindly tell. His photo is there.
His right hand side middle. Your
In
name.
my
Page
particulars
151.
of fraud,
151.
in my particulars of fraud, apropos this document, I have said that the signature is obtained by fraud.
Where? In the amendment?
In the amendment application.
Show me that.
Show
me that.
Kindly have a look at the amendment application. No? It starts at 422.
Affidavit affirmed before Metropolitan Magistrate, my lord. His photo is
that anyone can challenge that.
No.
Yes, not your lordship, 435.
435.
435 and a unilaterally registered purported deed of declaration.
Forge the signatures.
4th May 2010 have compelled the plaintiff and their signatures forged the signature plaintiff on the purported deed of declaration dated 1st June 2009. First particular of fraud. Refer to in paragraph 10 above. It remains a partition suit, not whether
the deed of declaration dated 4th of May 2010. There is another deed of declaration.
A. 435A. Defendant number 1 has forged
with regard to June 2009.
2009.
And there is another deed, B.
Yes,
of May.
There's some other deed of declaration. There's another deed of declaration that they've come and disclosed. This property, so whether I succeed in the suit or not, I'm entitled to challenge these documents. If he comes and in 711 he brings in new documents asking the court to dismiss my suit, that's a little extreme and harsh. I've challenged these documents, and it comes for the first time to me in 2000 in the 711. And your lordship, that's why I wanted to just place that one paragraph. Registration actually happens after I file the suit. So then where would I have gone? That's why I said I'll just place that one paragraph and I won't need to.
Anything in reply?
No, I'll leave it to you.
All right. Heard the learned advocate.
And I'm formally citing the 2022.
Yes.
Grateful.
Thank you.
Item number 29.
Item number 29, your lordship, Mr. Shaunak Bhattacharya, the appearance on behalf of the petitioner. Mr. Shaunak Bhattacharya.
Since I'm not inclined to take up this matter on personal ground,
Number 30.
In this matter, your lordship, I beg to appear for the petitioner, lordship.
Yes.
So the petitioner is the father of a minor son who is in custody of the opposite parties. So the petitioner filed one application under Act 8, which was registered at Act 8 case number 7 of 2025 for the landed 16th ADJ.
We want expeditious hearing.
Okay.
This application under Article 227 of the Constitution of India is
under Order 39, Rule 7. My lord, without serving a copy of the said application, learned trial court below considered the matter and allowed the Order 39, Rule 7 also. My lord, I am challenging only the part of the order which allowing the Order 39, Rule 7 without serving copy. Copy. My lord, last part of the impugned order is a order allowing the Order 39, Rule 7 without serving copy, which violate Order 39, Rule 8, my lord.
এই কোর্ট ফিজ একটা বোধহয় কোর্ট ফিজ একটা সে কিভাবে দিয়েছিলেন একটা না না এই তো এই কিভাবে দিয়েছিলেন
Lord, application, the plaintiff paid at 39 Rule 7 because of they have residing in a dilapidated house building, and that house building required to be repaired, and but the repairing application was not filed. And apart from that, also it is stated that plaintiff defendant number 1, 2, 14, 15, 16 trying to change nature and character of the suit property, trying to sell out the property more than their share, and on that ground this 39 Rule 7 was application was filed, and learned trial court without serving considered this
The
application.
learned advocate appearing for the petitioner submits that the application the learned advocate appearing for the petitioner None appears for the petition at the time of call.
Number 33.
Lord, I am appearing on the petition.
Yes.
Lord, in this matter from impugned order, your lordship will find that wife is entitled to get amount of rupees 28,80,000 towards the area of maintenance.
Yes.
Now, if your lordship heard the fact remains is husband filed a suit for divorce, wife filed a suit for maintenance. Both the suit were running. Thereafter, both the suit were fixed for final hearing. In maintenance case, wife adduced evidence, opposite party cross-examined. They disputed the documents which was filed by the wife. Even then, your lordship will find trial court passed the ex parte order. That should be contested order. Instead of that, the trial court passed the ex parte order. And after lapse of 4 to 5 years, husband came with order 9 rule 13.
So order of realization of the arrear above.
Yes, my lord.
That order was subsequently set aside on consent.
No, my lord.
Yes. From the recorded such ex parte order of maintenance was set aside on consent of both parties. And subsequently the same was disposed of on admission by passing on maintenance allowance.
But that 30,000 on consent 30,000 was paid with effect from the date of passing of the order.
Yes.
From that order, he is paying 30,000 rupees.
Yes.
Now the question is,
where is the order setting aside the ex parte degree? Setting aside the this order?
Particular that order is not it.
Then
particular
the recording of the court. This application under Article 220.
before I appear for the caveator opposite parties, that kindly take it up tomorrow, subject to my lord kind sanction.
Why?
Lord, I have just received, Lord, I have just been briefed.
Senior advocates get ready immediately after receiving.
Lord, kindly hear Mr. Chatterjee if my lord desires, if my lord desires, Lord, kindly hear me tomorrow.
Yes, what is this? What is the issue?
Section 8.
Section 8.
Rejected on the ground of the arbitration.
Arbitration Act.
On the ground, Lord, that I haven't given the original along, Lord, with the application. But my case is that the original is with my learned senior friend's client. So if it is not with me, then I cannot produce it. And we have a few decisions on that as well. But the other part is arbitrable. It will take a little bit of my lord's time. It's not that the only problem that I have is 11th of August is the date fixed for my lord filing my written statement. So if that, my lord, if my learned senior friend, because I don't know what happens tomorrow, because the other matter, my lord, has gone down to 300 something. I am not sure what's going to happen tomorrow. If
Not today, yes, next.
No, my lord, I cannot. Serious problems. Basically, 11th of August is my date fixed. Let him file without prejudice. Let him file without prejudice. No, I don't want to do that.
File what?
Written statement. I don't. He can file without prejudice. My lord is granting liberty. That liberty would be exercised. He will file a written statement. We shall pray for time. I'm not saying, my lord, that your lordship stays anything. I'm saying that we shall pray for time that my learned senior friend not oppose that. That is the only thing. And if it's taken up tomorrow, my lord, if it's taken tomorrow, there is no problem at all.
Not today. The parties will be at liberty to pray for.
Item number 35.
For the learned trial judge. Yes, next.
It's my application option.
Let the matter retain its position in the list. Let the matter
In
retain.
this matter, petitioner has paid for expeditious disposal lordship by challenging the order dated 9/7/2025. This is a suit for eviction lordship. There is a application filed under 7(2) of the West Bengal Premises Tenancy Act. The said suit has been pending since 2014 lordship, and without unreasonable
This application under Article 227 of the Constitution. Yes.
Well, this is my application.
I am
Yes.
for the caveator of it.
Yes.
Now, my lord, the executives of a will is before your lordship as a petitioner.
What is the impugned order?
Impugned order, my lord, one under order 208 of civil rules and order for police health, and another one is, my lord, that order 21 rule 35 recommend the padlock. Now, my lord, admittedly, my lord, the probate proceeding is pending, and they are.
What is this proceeding?
This is arising out of the, my lord, the eviction suit. Eviction suit, my lord, arising out of the eviction suit. Initially, eviction suit was dismissed. Then, my lord, appeal paper before this honorable court. My lord, appeal allowed. My lord, thereafter up to Supreme Court. my lord, that has been, my lord, not entertained, upheld by the judgment of the division bench. Now, the fact remains, my lord, that suit was represented when I was the one of the director of the company.
So, Pan, can I go into those aspects?
No,
now?
certainly not.
So now,
Only thing is, these are only things, subject to your lordship correction, that my probate proceeding is pending independently. I have filed an application under order 21, my lord, rule 97. Against the refusal, appeal is pending before this honorable court. With the section 5 application, the decree holder sought for filing objection, and matter has been fixed on
decree
5th
holder sought for
for filing file objection to the section 5
before this court.
Before this court in an appeal. Now, my lord, 5th is the date fixed for the hearing of that appeal.
5th of
5th of August. In between, my lord, police help has been directed to execute the decree on 25th of this month. And admittedly, my lord, my suit is, my lord, my probate proceeding is pending.
Why
Now,
police, Mr. Pan, why are you inviting the police to go to your property?
Because, my lord, the
police will not go. Why police will go to evict you?
Well, that is the order.
I am asking you, are you inviting these police to come to your property to evict you?
No. My lord, I have registered. Admittedly, my lord, I registered.
Why are you resisting? You are a law-abiding citizen, Mr. Pan. No, and you are resisting a decree.
No, registering a decree, that's why, my
Decree
lord,
is operating against you and your...
no, not against me. Decree has not passed against me. Decree has not passed against me. Decree has been passed, my lord, even assuming against the tenant. My lord, I was put into possession, my lord, when the will was executed. I was put into possession, and since then, my lord, I am continuing with the possession. My lord, subject to your lordship correction.
Police will not go, Mr. Pan. Please vacate.
No,
I will
my lord,
restrain the police from going.
no, my lord,
there.
kindly see, my lord. My lord, my right to the property will be jeopardized. My right to the property, suppose, my lord, if I succeed in the probate.
144 is there, Mr. Pan.
Yes, I admit to that. I go down to that.
You succeed in the appeal, get back the possession immediately thereafter.
No, kindly give me within time, my lord. Subject to your lordship, I like to cite one judgment before your lordship.
Yes, Mr. Mukherjee, 5th of August is the date fixed in the appeal.
No, not appeal, my lord. I will. My lord,
the stay application will be hard on 5th. You oppose.
Let Mr. Pan finish. Thereafter, my lord, I shall. No, sir,
Of August is the hearing of the.
My lord, kindly consider. My lord, this, my lord, suit, the lady who has filed written statement has taken a plea that specific performance suit is pending. There is an agreement for sale. A will is there. A construction agreement is also there, memorandum of undertaking. All this aspect has been Salt Lake property. My lord, all this aspect has been gone into, and this honorable court finds that he is nothing but a loanee and whose loan has been liquidated. And other document has said to be concocted and out false story, affirmed by Supreme Court. Supreme Court said you file an undertaking. They say yes, I will file an undertaking. Thereafter, fled away. No undertaking filed. Thereafter, they have taken out an application under section 47. But kindly bears on your lordship's mind, I am compelled to say that by the same advocate on record. Third party is also coming by the same advocate on record. The judgment debtor is also coming by the same advocate on record. 47 came before this, 47 file said res judicata. These issues decided in this suit. Came back before your lordship by filing a revision. Your lordship, now the live streaming are available, that we can take advantage of that. Your lordships opine that look how you, because in 47 the court opined that order 21 rule 99 you filed on the self-same issue rejected. Your lordship opined how challenging order 21 rule 99 order you have filed a revisional application that was filed and kept pending. Even after my lords that observation, they said yes, that is not maintainable. Thereafter also waited. This 47 revisional application is pending before your lordship's court. They thereafter withdraw that revision before your lordship. My lord did not grant them any leave, specific leave. They went there, trying to take advantage of section 14. That's why I prayed for the opposition to be filed. So it is a stillborn appeal in the eye of law. And if my learned senior friend wants to canvass that citing of or pendency of a probate proceeding gives them at all an independent right to object a decree, because my lord, Order 21 Rule 99 is very specific. You have to assert as on today what right you have to remain in the property. And section 211 and section 213 of the Indian Succession Act, very clear. If you are a Hindu, you don't have any right till the probate is granted. Now, my lord, the question of probate and all that has been adjudicated, and these issues has been said to be res judicata here. So today, after all this battle, when they have seen that everything is now out of their hand, they have filed and taking a window from your lordship. This is not a mere asking. This is such a conduct. And Lord, your lordship has passed a deliberate judgment. Kindly see, recording their conduct, times and again challenging the one after another, Lord, order of the executing court for recalling in 208 proceeding, for recalling of witness and all that. Your lordship, by a elaborate judgment,
have a photocopy of this.
Yes. Photocopy that? By a elaborate judgment, my lord has dealt with and directed the executing court to proceed and dispose of this 208 application. Mr. Pan was not there, my lord, at that juncture, but Mr. Das was there. Because Mr. Das is frequently coming both for, even in the other proceeding before this honorable court, he appeared for this.
Now I recall.
Yes.
So list of dates I asked
yes,
you.
Yes. This is a checkered history, my lord. Otherwise, my lord, in a other matters, my lord, your lordship for times and again is saying that wait for some time. This is not a matter for that. The Honorable Supreme Court's registry has been compelled to communicate this Honorable Court that look, by virtue of the order of this Honorable Court, they have not complied and did not file undertaking.
This is this petitioner. Undertaking.
No.
Yes, yes.
No. This is a company.
Yes, I'm coming, my lord. That's also, I'm coming. My learned senior friend has.
My lord, I was one of the directors during pendency of the suit. I resigned
Not
from the
suit.
director.
Again, wrong statement. In appeal.
I have been told আমরা তো শুটি before passing the dismissal of the suit তো আমরা resign করেছিলাম
এখানে ডিক্রির আগে রিজাইন করেছি
ও এই first step
I know, my lord, when this honorable court, my lord, there, my lord, for the very beginning, who has affirmed this affidavit, my lord, this written statement, Ganga Bhoda. She has agitated everything. My learned friend's contention is that no, Ganga Bhoda has been arrayed as one of the director of our company. In the written statement, Ganga Bhoda has stated everything in respect of her independent right also. That has been adjudicated by this honorable court and also the Honorable Supreme Court.
But with due respect, possibly my right as a executive, possibly that has not been adjudicated.
Very well, my lord.
I need to, as an executive, possibly that right has not.
You are in possession.
I am in possession.
Since when?
Since the very inception, my lord. Since the date of from
how much amount you are willing to deposit? How much amount you are willing to deposit? I will grant stay.
My lord,
provided you lose, that amount will be forfeited.
Towards the occupational charges.
Yes. Condition for stay. That will be deposited. If you lose in that appeal, amount will be forfeited.
In 40 rule 21 rule 47. Yeah, 97.
Yes. That amount will be forfeited, and it will be a meager amount because you are in possession for a long period of time.
What happened, my lord? We sought for the accounts. Not that they are
that everything now, since you are suffering a decree, you are in possession. You pay some amount. I will allow you to stay. Allow you to move the appeal.
2 minutes time, my lord, to get the instruction. 2 minutes time. Just 2 minutes time.
What's the extent?
Not entirety of house.
Yes. Tell me what is the extent.
3 quarters land. I constructed the house.
3 quarters of land. Yes. What is the constructed area?
না তারপরে কতটা adjudicate হয়েছে?
2,500 square feet per floor.
Plus
2 floor per floor.
2,000, so 5,000.
No.
That is our specific.
2,300 square feet, 3 quarters land cannot be. I stayed in Salt Lake.
3 cutters of land.
Cutters,
Can't be.
Mr. Mukherjee cannot be 2,500 per
500.
floor. What are you saying?
Together. Altogether 2,500, I understand.
3 cutters is 2,100 square feet in
Yes.
totality.
In
How
totality.
there can be 2,500
Yes.
per floor?
Lord, my learned friend is asking, not in the other way. My learned friend is asking that he wants to try his luck before the division bench. Why not before your lordship? Section 47 application rejection is pending before your lordship. Once Mr. Dotto appeared for the same person, your lordship did not allow. Yes, no, Mr. Suman Dotto.
Oh, Suman.
Yes.
Yes. Oh, yes, I posed him 2 questions.
Yes, that matter. Your lordship keeps it. I am ready with section 47 also. This is in the list. 147 item number. Let my learned senior friend place his matter.
Yes, Mr. Kapan. Now I recollect. 2 issues I posed him, then he played away.
Divisional application.
Then he played away.
Now, only thing is, my lord, only thing, my lord, I have gone through the entire brief. My lord, I must be candid to your lordship. My lord, so far the other than my.
What is the constructed area, Mr. Pan, according to you?
Constructed area, my lord, will be, my lord, together 2,200 something like that in both the floors, in 2 floors.
2,200.
200.
So 2,000. Let us accept. And what is the market rate of rent in that locality? Because you are aware, Mr. Pan, what's the market rate of?
I tell you, lordship. I want to candid to your lordship. This is not a commercial building.
No, residential.
This
What's the market rate of rent?
Depends upon the area. Depends upon the area.
Yes, this area?
This is in sector 3.
Yes. What will be the market rate of rent?
Sector 1. BC.
Sector 1.
What will be the market rate of rent? According to your own estimate, per month?
30,000.
30,000. And the decree was passed on?
16th February 2023.
16th February 2023.
2023. So more than 2 years.
By the appeal court.
By the appeal court.
And the earlier suit was dismissed.
All right. So let us take it. So more than 2 years. So 30,000 per month, more than 2 years. What would be the total amount? Deposit it. It will be forfeited if you lose in that.
No, not in that, my lord. Before your lordship also same thing. That's why I intimate before your lordship. This is not something.
So, my lord, kindly bear with me. My lord, I am very much scared to bargain with the court, my lord. But humbly praying before your lordship, if your lordship can allow us to deposit, my lord, within a day or 2, 5 lakhs. Then, my lord.
This is nothing. Salt Lake? I thought of something more you would quote. 5 lakhs is.
Mr. I leave it to your lordship. 5 lakhs, my lord. 5 lakhs.
Where is the section 47?
No, 177. Today there is 177.
But I am ready.
Are you ready with the section 47?
I am not ready, my lord.
Tomorrow I am fixing this along with that.
25.
I have some personal problem, my lord.
Day after tomorrow?
Day after tomorrow.
Day after tomorrow?
Day after tomorrow, my lord, I will. Day after tomorrow, kindly fix it up.
Day after tomorrow is 24th.
And my lord, so far the deposit part is concerned, my lord, I am ready to pay whatever.
Let me see, 47 if goes, everything goes.
No,
47.
47 is subsequent to, my lord, the order 21 rule 97. That is earlier.
Mr. Pan, whether order 21 rule 99 is maintainable or not, that will be decided in 47.
So, my lord, kindly, my lord, I am ready to deposit, my lord. Let me try my luck in the appeal, my lord. I am depositing the money, what has fallen from the court, my lord. If whatever.
24th. Come on 24th. Let me see what happens. Ashun, when this Call the next matter.
Item number 37.
My lord, item number 37, I beg to appear on behalf of the petitioner. My lord, I stand for an apology. I am suffering from viral fever. I am appearing online. My lord, kindly excuses. My lord, this is an application where I am aggrieved by the order of the learned district judge in an application under section 9 of the Arbitration Act. Now, my lord, the reason why Article 227 supervisory jurisdiction has been invoked is because, my lord, with utmost respect, the order suffers from manifest error of an understanding of the learned judge's jurisdiction. My lord, I promise that this shall not entertain any review on the merits. My lord, straight away comes to the impugned order, which is
Order passed under section 9, it is an appellable order.
my lord, no order has been passed under section 9. That is what I shall endeavor to show. Kindly takes up the impugned order number 2, 21st of June, my lord. And my lord kindly bears with me while I demonstrate where, with utmost respect, the learned judge has not understood the jurisdiction at all. My lord kindly sees deficit court. May I place, my lord, the impugned order? Yes. Deficit court fees is filed today. Office to check and verify the court fees. Now, my lord, present case is under section 9 of the Arbitration and Conciliation Act arising out of memorandum dated such and such. Considered. My lord, totally non-speaking as to what was considered. Issue notice, put requisites. My lord sees the next date is tomorrow. Now, my lord kindly sees the portion coming later. My lord has found that.
Yes.
The learned advocate for the petitioner moved an application under Order 39 Rules 1 and 2. My lord, utmost respect, no application under 39 1 and 2 could have been called for. Now, my lord kindly sees, heard. Only it is stated in the application the facts already narrated in the miss case. Now, the miss case, my lord, is my section 9 application. And thereafter it is written that there is a strong prima facie case. On perusal, my lord kindly turns over of the schedule, I find that huge landed property is the subject matter. Kindly sees, my lord, consider, issue notice, etc. Now, my lord comes to the last paragraph of that order. Since prima facie case is not made out as per the contents of the application under Order 39 1 and 2, the prayer of ad interim injunction. Lordship, with the utmost respect, not only did the learned court, and this is on instruction, my lord, not only did the learned court first call for an application under Order 39, my lord, the order is totally non-speaking, and the only reason why the learned judge of the learned court below has come to this finding is that he has not considered the section 9 application, only says that I have reiterated my section 9 case in the Order 39 1 and 2. Now, my lord, this is with utmost respect.
According to you, there is Order 39 Rule 1 and 2 application being filed.
No, my lord, there was no, the arbitration.
Tomorrow is the next date fixed. You
Yes.
bring to the notice of the learned judge that you did not file any application under Order 39 Rule 1 and 2. Tomorrow.
No, my lord, we had to file an application. The learned judge, and this is on instruction, the learned judge said that a section 9 cannot be considered until and unless a prayer for ad interim injunction under Order 39. Now, my lord, I will not trouble my lord with a judgment. My lord knows the Arbitration Act is a complete code. There can be no requirement in law, and kindly sees the impugned order, my lord. He's not even considered my section 9 case. With the utmost respect, my lord kindly sees the last paragraph of the impugned order speaks for itself.
So have you served the copy person? Have you complied with the direction
Yes,
of service?
absolutely, absolutely. I'm instructed.
Madam, tomorrow is the date fixed.
Yes.
So appear before the learned trial judge.
My lord, my only difficulty is this. My lord sees from the order impugned, with the utmost respect, the learned judge is possibly in error of understanding of a jurisdiction of a section 9 court. If for some reason, my lord, tomorrow, even after SRAD, the opposite parties before my lord today do not appear, and then my lord kindly sees order number 1. I had filed this on 8th of May, and the next date is being given on 23rd of July. Now, my lord, my case, I will not enter into the merits, my lord. I am well aware of the constraints of a 227. My lord, I stand to a section 9 is catering to urgency, my lord. My lord sees the impugned order with utmost respect, and with folded hands, I submit before my lord, the learned judge of the learned court below has not understood the section 9 jurisdiction. My lord kindly grant some protection, at least an order of status quo as to nature, character.
Madam, the date fixed. I am giving you liberty to move your prayer for ad interim order tomorrow.
My
Considering
lord kindly does not dispose of my application today, my lord. I'll have to come back with another.
with the date fixed, if any order is being passed, you are free to challenge that.
Then my lord kindly grants me this much. My lord makes an observation at least that order 39 1 and the section 9 be considered on merits, my lord. Let the section 9 be considered.
Yes, the learned advocate appearing for the petitioner submits that the petitioner filed an application under section 9 of the Arbitration and Conciliation Act, and the learned district judge Purbo Bardhaman, by an order dated 21st of June 2025, directed the petitioner to issue notice upon the opposite parties. And 23rd of July 2025 has been fixed for service returns and acknowledgement due. First of the learned advocate appearing for the petitioner submits that in compliance with the said order, the notice has already been served upon the opposite parties. First up, the learned advocate appearing for the petitioner further submits that though an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure was filed, but the petitioner has instructed the learned advocate to submit that the petitioner shall not press the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, but shall proceed with the application under Section 9 of the Arbitration and Conciliation Act. First of such submission of the learned advocate for the petitioner is placed on record. First of considering the fact that the 23rd of July 2025 has been fixed by the learned district judge, this court is not inclined to interfere with such order. First of with the above observations, your number such and such stands disposed of. Yes, call the next matter.
My lord kindly includes one observation that in a section 9 application, the rigors of order 39, rule 1 and 2 procedural rigors do not apply.
You will not press Order 39, Rule 1 and 2. You will move your Section 9. Please move your Section 9 application.
Obliged, my lord.
Yes. Yes.
Lordship, my lord, previously appeared in for one of the parties.
It has been submitted that I had the occasion to
Hey, Vishal, please name to the committee.
अच्छा ठीक है नंबर टिक दिया
Order number 168.
Lord, police help has been granted, my lord, for implementation of a ad interim order of injunction. Lord, I have an application to Order 39, Rule 4, which is pending. Of course, there's a line of decision which says that for an ad interim order of injunction, police help cannot be granted. And moreover, my lord, I have an application to Order.
I have also delivered a judgment last Friday.
That's Lord, the injunction which was granted was.
What's the order of injunction?
Just these days I can't see anything without the. Lord, if your lordship turns to page 27, that's the order of injunction. And the. I'm sorry, yes.
From making any construction
over the suit properties till 5th of October 2023, and this was not going.
And when this order of injunction was passed?
This was passed on 31st of August 2023.
Mr. Chatterjee, you have entered appearance, so this order was extended in your presence.
Yes, I am not doing. That's what my point is. Seize the application once.
So what is the difficulty if the police goes and sees? We will find that you are not
stopping me. The police entering my premises, my lord, itself is a stigma on me. Kindly appreciates that. If the police is entering my premises, that itself is a stigma.
No.
And if I am flouting, I would have understood. Have a look at the application once.
Constructing.
No, then the police should not go. Have a look at page 28
and submit a report. What the difficulty is that?
What's the difficulty in that? Seize 28 once. Kindly have a look at 28. Looks at 28.
Yes.
Seize paragraph 3. According to them, my lord, if your lordship sees, paragraph 3 is my application under order 39(4), which is pending.
Yes.
Then sees, my lord, paragraph 4. The defendants state and submit that in the said objection, the defendants have entirely denied the allegations made by the plaintiffs. Not only that the defendants specifically stated in their objection that out of the 17 plots in question, these defendants are the joint owners of 3 suit plots in question, that is 5104, 5105 and 5147. In 5104, total land measuring such and such, the defendants are the owners of 44 shatok, and the plaintiffs are the owners in the said plot only measuring 28 shatok. And the said land are used by the defendant only for the ingress and egress and not to do any type of work out whatsoever in the said land. Then 5015 also is described in the same way, turns to 7.
Yes, I've seen 7.
My lord,
I've marked 7.
Yes, my lord. Then see, are nowhere related and not carrying any doubt.
You have given me a marked copy, so it helps me.
No, my lord, it's my fault. I'm sorry, my lord.
No, it helps.
No, it's
So,
should not be.
so I'm
this
going
is-
to those markings, and I know what he will be submitting.
In a way, my lord, it's good in this matter, but in some other matter, if your lordship remembers what happened to Mr. Mukherjee. So in a situation like this, where the police have given granted, kindly have a look at.
So did you file any objection to this application?
Yes. Kindly have a look
Your
at
objection.
impugned order. 7th paragraph, 6 or 7 paragraph.
Raised objection? No, you did not file any.
Yes, objection is at 37. 37.
Page 37.
Yes, it was not considered as a different thing altogether. I'm subject to correction. Yes, 34 is the application and 37 is my objection. And again, my lord, if it's marked, that your lordship will see at paragraph 6. And then your lordship will find, my lord, the other parts, the suppressions and everything. This was not considered. The oral objection was considered. And if it's, my lord, I am saying, my lord, if there are 3 or 4 plots involved, there has to be an order 26 rule 9 application which is filed. That needs to be heard. Whether I am making a construction in those
17th of July, what happened?
My lord, this month.
Yes, 17th of July.
Nothing happened.
From the inspector in charge of Rajarat.
No, nothing happened. Subject to correction, nothing happened. Report, my lord, has not been, my lord, put forward. Let them come, but in the meantime, my lord, kindly stays this order. It can't be, my lord, that the police will go every day, my lord, into my property. And just visualizes the situation, my lord.
Mr. Chatterjee, when there is an allegation that construction, they let the police. It's not a
Police
question.
can't, not the police. Send somebody. I have filed an order 26 rule 9 application. I have filed it. I have asked the court to investigate on that.
What's the
Not
difficulty?
police. Lord, it's a stigma. Your lordship knows.
What's
the police being involved in a civil matter is
So
as the last thing that should happen. In the meantime, Lord, if the court can, out of its own machinery, find out, order 39 rule 2A is there, I will go to
caveat in this?
Nothing. Like a absolutely unreasoned order, doesn't consider my objection at all. Next date ta kabe?
What is the next date fixed?
Ekhano pawa jayeni. You haven't.
17th was the
17th. It should be sometimes in August. Well, I'm sure the police will not. We have probably will not inform the police that we
the
have
only
gone.
difficulty is that ad interim order of injunction was on 2023.
Yes.
So it was extended in your presence.
Yes.
And there's a decision of a coordinate bench which says this changing the nature of character, if it is extended in your presence, police help can be granted.
Well, if the police help can be granted in a certain situation.
Where is that decision?
Where is
that decision?
Well, that is for them to find and come and tell your lordship, not me. At the present moment, I'm an officer of court, I understand. That's why I said, there is a decision.
Mr. Chatterjee, I'm aware of.
Situation where, Milord, where it is admittedly that I am flouting the order. I am saying I am not.
It says only, I think, 3-4 paragraphs judgment. First paragraph is an ad interim order. Second says extended in the presence of the other side. So it
I am
has to
the
be
last
implemented.
person to say, Milord, that if there is an order of injunction, it should be flouted like anything.
So
I
that's
can't say that.
Because it's Mr. Chatterjee, only thing is it's continuing from 2023.
It is.
And this order.
Milord,
has
I
been
am
passed.
saying,
There are cases, Mr. Chatterjee, where
gives me,
the ad interim order
I'll make
of
this up.
injunction is
I'm making this submission. Today sees that there is a dispute as to where the construction is being made. 17 plots are involved in the suit. There is a dispute as to where the construction is being made. It's the civil court which has to decide.
Oh, Mr. Chatterjee, this order was passed in March.
Yes,
I'm directing you to serve. Please serve
yes,
them.
but
because,
in the meantime, let them not go henceforth. If they have
Nothing.
gone, I cannot stop it.
So from
Henceforth,
March, nobody knows how many times they have gone.
they
Petitioner,
so,
the
the police is harassing. No, I am praying for earlier. Calcutta, Milord, I'll try on the 5th.
Calcutta, Mr. Chatterjee, because service.
I'll try on the 5th. 5th. No, the problem is, Milord, the clients here, no, they're trying to make construction, Milord, with their hard-earned money. And suddenly, if the police comes and your lordship, if the streaming is not on, your lordship knows what I have to do. And this is a practical difficulty.
Strategy, I know that this in this way it should not be passed, but there's a distinction, Mr. Chatterjee, between possession and construction. That's the distinction. You know, Mr. Chatterjee, very well the decision.
That's Kishore Koitan's, Milord.
No, not the Kishore Koitan is on status quo. The status has to be indicated. This court's judgment.
Acha. ठीक है sir. I understand. Absolutely.
That was also ad interim. But there's a distinction, as you have said, started with saying, ad interim order of injunction, whether can be implemented.
There are 3 decisions which say it can't. Milord, I am saying, Milord, that section 36 will come into play.
36 temporary injunction cannot be 36. It's order 21. Order 39.
Milord, 30 ad interim has to come under 36.
Yes. So
as Justice Joint Vishwas's judgment.
But
and the provision is that
if you see Justice Bhaskar Bhattacharya's judgment says order 39 rule 2A. Not
order 39 rule 2A will come in.
Justice Bhattacharya has considered the relevant provisions of order 39 rule 2A and order 21 rule 32.
Yes.
which is according to you, section 36.
Yes, and then order
As well as order. So Lordship says, no, not under order 21, rule 32.
here, my
It
lord,
has to be, because it's a temporary injunction, that's a decree.
if
When
I'm
there's
not
a specific
mistaken,
provision,
Justice Dipankar Datta also held
but that's the
holding-
previous, Mr. Chatterjee, I've considered all those because I've.
in the earlier. May I have
That's earlier.
the name of the matter, my lord, so I can also look into it. Mr. Rai appeared, I'm sure.
Where?
Mr. Pratapati.
Mr. Chatterjee, it's difficult. I cannot, I have not.
Item number,
considered that.
anytime, my lord, if it's very soon, it will not be up.
SCC online, you will get those.
But it will not come in, my lord, so soon. It will take a little bit of time because your lordship has given this judgment, my lord, recently.
My judgment, that I can give you reference.
হ্যাঁ,
So,
ওটাই চাইছি। And then I'll look into this. হ্যাঁ, ওটা
CO 2368 of 2025.
Like
CO 2368 of 2025.
368.
Judgment delivered on 18th of July 2025.
18th of July. I'll look into that. That would.
I've considered that added trim, but that was in possession. That was on possession. And so I was aware of this. There is a judgment on status quo or this nature and character. That decision, I think, on maintenance of status quo with regard to the nature and character.
That was Kishore Koital.
This court said. Kishore Koital is 2006,
Yes.
volume 3 or 4
Yes.
SCC.
120.
Yes. So,
Kishore Koital, I did it in Calcutta. I lost
so,
here.
no, not Kishore Koital, another. So the proposition was that if it is extended, ad interim order extended in the presence of both sides, can be implemented by way of this. That's the ratio of that judgment.
I'll have to look into it.
So that's on changing the nature and character. That is why I am, because this is on possession. My judgment is on possession. There's a distinction between possession
I'll come back with
and nature and character.
I'll come back with that.
And if you want, Justice Bhaskar Bhattacharya's
Must be considered here, my lord, in my lord's judgment.
No, I have not referred to that. I've not
I'll
gone into
find
that. I've considered Justice Datta's judgment.
Justice Datta, Justice Joint Vishwas.
Section 36, I have not gone into that part because there is a divergence, because Justice Bhaskar Bhattacharya's judgment was prior in point of time, which says.
But it's a single bench judgment.
That is also both a single bench.
All three are single bench judgment.
All are single bench, but there Justice Bhattacharya has considered Order 21, Rule 32.
So my lord has
Order
elected.
21, Order 39, Rule 2A. What's the distinction in these two? And unless it's a decree, Justice Bhattacharya's view was that if it is a decree, then Order 21, Rule 32. If it's temporary injunction violation, it has to be Order 39, Rule 2A. But
Yes.
Justice Datta's view is
So
different.
that's exactly my point as well, that you could not have gone directly to police help.
So that's the, in other way, Justice Datta's judgment is there. Order 21, Rule 32 cannot be directly because it requires an adjudication.
Exactly.
That aspect
situation.
That aspect I've considered, and I've also considered.
This is exactly what I was trying to
also
talk.
considered the whether this ad interim injunction can be implemented.
Odisha High Court had earlier, my lord.
Kerala High Court initial.
Everybody said
So that, and Supreme Court also not in this under 226, where police protection can be granted.
That is
So there has to be some adjudication.
exactly.
It's ad interim, it's not adjudication.
Not adjudication, and moreover,
Rights are to be decided either at the interlocutory or at the final stage.
but there's again, if there is an injunction that has to be also to be honored.
Yes,
but,
so that's the.
there is a
that's-
way to get it honored, but not.
So there are
has to
two
be
ways.
Adjudication under 2A.
An order has been passed, you cannot say that it will be violated and the court will shut its eyes
Its
and
eyes.
sit tight.
That's why an order 39 rule 2A is very important to adjudicate whether there has been a flout.
Yes.
Directly going into police help can't happen.
So that is why please bring that judgment on nature and character.
I'll do that.
I've forgotten that.
I'll try and find out for your lordship. My lord, your lordship.
I can
still
give you the name of the author.
Other?
Justice Jyotirmoy Bhattacharya has passed that.
Well, we have it.
You have got that? Yes, so that is on or ad interim order of
Have it.
extended.
I didn't want to show it, but এখন দেখি কি হবে?
That's on. So extension in the presence. So you are aware of that.
No, that we have, but the question
That is against you.
they're not against me. I am saying that there needs to be an adjudication.
There is no question of adjudication. It says that's the distinction. Nature and character, you cannot say, I'm changing.
Today, my lord, if I'm not doing anything, then that needs to be adjudicated first, and then, my lord, the police cell will come in. Not before that. My lord, if a plaintiff has something, but he has to get back at me, so what he does, my lord, in a malafide way.
Two distinctions. One is with regard to possession, other is with
Yes,
regard
my
to
lord.
nature and
I
character.
bow down, my lord, completely
So
bow
there
down.
are two line of decisions. So
I
you
bow
can make
down.
your submissions on that because this is really on nature and character.
Bow down. Completely
So
bow down.
what may be applicable
My
to
yes,
possession may not be applicable to
absolutely.
nature and character.
Possession is admitted in my favor. Even I am saying in my order 39 rule 4, my lord, I am saying that the construction which is on is not
But
on
you
the
serve-
law. Yes. That's why I filed an application on order 26 rule 9. Without hearing all that, these
Bring all those judgments. So
on 12 pillar made me, my lord, some time be fixed so that I can finish it off on
well, I'm keeping hopefully because
the morning, my lord, if you're also kindly.
morning. Yes, call the next matter.
Right.
I do not think that would be great.
Go to us. So please. Yes.
There was no caveat as such. She's been served, so she's appearing. Malad, this is a matter wherein, my lord, a proceeding has been initiated without any jurisdiction at all. Now,
Proceeding under
my lord, the SARFAESI Act has been initiated without any jurisdiction at all.
Why?
Why I'll say, my lord, the cardinal principle of, my lord, a proceeding under, my lord, 13.2 is that one has to show that there is an NPA. Because, my lord, there are 9, my lord, schedule which has to be fulfilled. Now, this is a case where there has been no NPA at all. I file an application SI immediately saying that you're acting without jurisdiction. Now, my lord, without hearing that, the, my lord, 14.2 application is filed. I file an IA that has been rejected. And, my lord, first is fixed, my lord, for, my lord, publication of the, my lord, advertisement for sale of my property. Now, my lord, I come at the first instance saying that you have no jurisdiction at all. My lord, that is not being heard. And, my lord, possession has been forcefully not being heard. That's pending. Essay has been pending. And I'll show, my lord, why I am saying it, and I'll show the Reserve Bank guidelines and the law. My lord, kindly come straight away.
So what was your challenge before the DRT?
My challenge is, my lord, essay, I'll show that he does not have jurisdiction under the Act itself. I do not need to go into anything. From their 13.2 notice, it is apparent, and from the bank statement, there is no NPA. And if there is no NPA, my lord, question of, my lord, proceedings under the DRT Act doesn't arise.
Where is, show me the order
Yes,
passed
my
by
lord.
DRT.
My lord, that, my lord, the order
Page number 81.
81, lordship kindly comes.
Page 81.
No, my lord, 82.
82, it starts from, kindly sees, my lord. In filing this petition, SARFAESI applying challenge the purported order of 25/3/2025. That's, my lord, the 14.2 order. Now, my lord, kindly comes to the relevant portion. That is, my lord, 83. It is true. It is true that no SARFAESI action can be invoked or any. This is on Shali and agricultural land. It is argued from the side of the defendant that although the land has been recorded as Shali land, the land is now being used as commercial purposes for the applicants and not for agricultural purposes as on the date of mortgaging such land. SARFAESI applicants have not filed any document before this tribunal to show that the land is actually used for agricultural purposes. In fact, it is established law that whenever a secured creditor alleges that the mortgage land is not being used for agricultural purposes, the burden of proof lies on the applicant. To prove that the land is being used for agricultural purposes, no photograph of documents is forthcoming to the tribunal. Scheduled property is being used for agricultural land. Further, the timeline or the limitation of 60 days for disposal of Section 14 application by the DM SEJM is directory and mandatory. This also I'll show, my lord, it has been extended without there being any cause, and that can't be done. There is a judgment now, my lord, 2 judgments of this honorable court. Now, my lord, the issue is not at all on that. Issue is, my lord, what is there. My lord, kindly sees the second paragraph at 83. I have taken a close look at the purported order of 25/3 passed by the learned SEJM Alipur. It appears that learned SEJM Alipur, this is very important, more or less has recorded and dealt the 9 clauses as enshrined in proviso to section 14(1)(b) of the SARFAESI Act. And I hit there. because my lord, that is mandatory that there has to be an NPA. Now, my lord, before I show the documents, I must show the law.
Banerjee, the only ground which I've taken before the tribunal was that it is Shali land.
No, my lord,
That's
absolutely
that's
not.
the only
That's
ground. Next portion
that is, my lord, that's the, my lord, the finding. But the main argument that he has recorded is, my lord, is the first, my lord, the second paragraph I read. I have taken a close look. This is important. Now, my lord, kindly sees. I bow down, this would fall from, my lord, kindly takes my essay, which is filed months before. My lord, kindly comes to page 42, it starts. Now, my lord, kindly comes to the relevant paragraph, that's paragraph R, my lord. Page 53. That is my ground, and this is been filed, my lord, with is not overnight. In December 2024, kindly takes R. Your applicant state that if the basic initiation of the action supposedly taken under the garb of SARFAESI Act and not in accordance with law, in that event, all actions may be taken under by the defendant under the said act are in the name of the ipso facto not tenable either in fact or in law. My basic, my lord, point is on jurisdiction, which he says, my lord, that is, my lord, been covered. Now, my lord, kindly takes 14. Kindly takes 14. Section 14, my lord. SARFAESI Act. But may I hand over one, my lord? Lord, kindly take section 14. My lord, I am not reading the top portion. I am reading, my lord, from, my lord, proviso. Provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer, secured creditor, declaring that. This is very important. Now, my lord, these are the 9 touchstones. The aggregate amount of financial assistance granted and the total claim of the bank as on the date of filing of the application. The borrower has created security interest over various properties and that the financial or financial institution is holding a valid and subsisting security interest over such properties and the claim of the bank or financial institution is within the limitation period. 3, my lord, the borrower has credited security interest over various properties, giving the details of the properties referred to in subsection 2 above. Then, my lord, kindly comes to 4. The borrower has committed default in repayment of the financial assistance granted aggregating the specified amount. Now, my lord, 5. Consequent upon such default in repayment of the financial assistance, the account of the borrower has been classified as a non-performing asset. And that's exactly why I argued, my lord, 14.4 and 5. Now, my lord, kindly sees the document itself, which they have relied upon. Now, my lord, kindly comes to their 13.2 notice. Very important, my lord. My lord, that's at page 33, my lord. That's the date, kindly notes, my lord, at page 30. 8th of July 2024, and in December itself I have challenged it. Now, lordship will kindly come to page, my lord, 32 and see the date of NPA. This is very important. My lord, lordship, from the top, if your lordship leaves, my lord, 6 lines, there is a sentence, my lord, which starts, the account of you, the addressee number 1, has been declared as NPA on 26/5/2024. Lordship has got
which paragraph?
My lord, page 32, first paragraph from the top. If your lordship leaves 6 line, there is a sentence which is there, my lord. The account of you, addressee number 1.
Note that since you have account of you, yes,
has been declared as NPA on 26/5/2024. So, my lord, this is the date of, my lord, which one has to look into, because this is the date of NPA, which triggers, my lord, 14.4 and 5. Now, my lord, kindly comes to straight away, my lord, page 79. Kindly sees, my lord, the amount at page 79. The date, my lord, page 17, lordship has got, my lord, the bank statement itself, kindly sees the date, 1st of April 2024. Because, my lord, I showed the date of NPA was 26th of May 2024. So, my lord, I have given 1st of April 2024, the last, my lord, entry. Now, my lord, kindly sees the closing balance. Minus 19,709,049. So, that's, my lord, 1 crore 97 lakhs 9,049. Lordship has got it, my lord. Now, my lord, kindly turns the page and comes to page 80. Kindly takes, my lord, first 29/4/2024. Kindly sees deposit amount 80 lakhs, 1 lakh. 80,000, sorry, 1 lakh. 1,80,000 entire interest paid, serviced. There cannot be any NPA. Then, my lord, comes to 1st of May 2024. Now, my lord, lordship will find 2 lakh. It got 2 lakh though. 3,924. Lordship has got it, my lord.
Yes.
Immediately after that, 30th of May 2024, 3 lakhs rupees interest paid. Lordship has got, my lord.
Yes.
Now, my lord, kindly comes to 30th of May 2024, because they, my lord, give the date of interest, my lord, as the date of NPA as, my lord, 26th of May. Now, 30th of May, therefore, my lord, interest is overdue in this account. So, there is no question of NPA. Now, my lord, let me show the law. Huh? Now, my lord, kindly comes to page 36 now. Let me show the law. I have enclosed it. My lord, this is from the, my lord, Reserve Bank of India guidelines. My lord, kindly takes page 36, clause 2, non-performing assets, NPA. Classification of assets as non-performing. A non-performing asset is a loan or an advance where the interest, lordship will kindly mark, and or installment principal remain overdue. As I showed, there was no overdue of interest at all. Everything was paid for a period more than 90 days in respect of a term loan. So, my lord, there was no question of, my lord, the amount being due more than 90 days when I have serviced it in the same month. Then how come in the same month on 25th, they say, my lord, that it is NPA? And thereafter, my lord, kindly sees what it would be. It would be at best, my lord, kindly takes the note, which is at the bottom, my lord, of the same page. An account should be treated as out of order if the outstanding balance is CCOD account remains continuously in excess of the sanction limit drawing over 90 days. So this, my lord, is not, my lord, nothing to do with NPA. Now kindly takes, my lord, what happens to these accounts. This is, my lord, kindly comes to page 39. These are known as, my lord, special mention account, which are, my lord, categorized by the, my lord, RBI, page 39. My lord, kindly sees there also in special mentioned account, principal or interest payment, or the word is or, payment or any other amount wholly or partially overdue for 30 days. Even that is not qualified. Because, my lord, I have paid on 1st, I have paid on 10th, I have paid on 25th. And on 30th, there was no interest due whatsoever. But this even, my lord, would not trigger 14.4 and 14.5. So, my lord, on the date that they initiate the proceeding, my lord, on that day itself, my lord, there was no interest overdue. There was no default to categorize it as a non-performing asset. My lord, if it is not a non-performing asset, my lord, it doesn't come under the DRT jurisdiction at all. Now, my lord, when I say this, what do they do, my lord? Kindly sees more, my lord, in what manner they are performing their, my lord, duties. Kindly comes to page 87. Lordship knows the series of judgments under section 14, where, my lord, enforcement, if it is not done, the, my lord, the concerned district magistrate, my lord, or the additional chief judicial magistrate can extend it for the purpose of, my lord, execution, not for this purpose. Kindly takes 87, my lord.
Yes.
This is the order passed on 25th of March 2025, my lord, by the, my lord, additional chief judicial magistrate. Now, my lord, kindly comes the reason for extension. Lordship will find it, my lord. Settlement. Kindly comes to page 91. Kindly record, sees, my lord. The petitioner has prayed for extension of order. Petitioner is the bank of this court on the ground of unavoidable circumstances, settlement of between the parties. Where is it? And this, my lord, cannot be a ground for extension. The order itself has lapsed under section 14. The only proviso under section 14, if your lordship sees, my lord, for extension is on the ground that it is not being implemented by, my lord, any issue that the court faces. Kindly take section 14, my lord, 2. For the purposes of securing compliance with the provisions of subsection 1, the chief metropolitan magistrate of the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may be in his opinion be necessary. Not for this. He cannot extend, my lord, any order, my lord, for the purpose of talks of settlement. And there is no talks of settlement because I've challenged the jurisdiction itself. There is no document whatsoever. Now, my lord, let me show their application itself, which is not maintainable. My lord, it starts from 103. This is the affidavit. Kindly comes to 102. This is the standardized format. My lord, I have shown the law. I have shown, my lord, the bank statement. Now see, my lord, an affidavit, they state false statements. Kindly comes to 102 page Roman 4. Lordship has got 100. Has the borrower committed default in repayment of financial assistance granting aggregating the specified amount? He writes yes, but the bank statement says otherwise. The borrower defaults in. Next, my lord, very important. Consequent upon such default in repayment of the financial assistance, the account of the borrower has been classified as a non-performing asset. He says yes on 26/5/2024, when on 30th May itself it is seen, my lord, from the bank statement that, my lord, no amount is due as far as interest is concerned. And then, my lord, kindly takes 103 Roman 8. The borrower has not made any repayment of the financial assistance in spite of the above notice, and the authorized officer is therefore entitled to take possession of the secured assets under section 4, subsection 4 of section 13, read with section. This is contrary to the bank statement itself. Kindly see page 81. When payments have been made, interest has been cleared completely. Kindly takes, my lord, page 81.
Yes.
This is the date, my lord, I have given 5/9/2024. INR, my lord, this is from their, my lord, website. 1,37,910. One-time payment, fully paid. And, my lord, I have a copy to the account, my lord, as on date shows closed. How can an NPA account be, my lord, declared as closed? Kindly sees, my lord.
Where is closed?
Yes, my lord, full closed. Yes, kindly sees the, my lord, loan status. We downloaded immediately after filing this, my lord, from the bank itself. Kindly sees, my lord, the date 9/7/2025. Lordship at the top right hand side. Lordship has got the date. Statement issue date 9/7/2025. That's the latest, my lord.
Yes.
Now, my lord, just come below that. There is a, my lord, loan status. Lordship has got loan status. My lord, principal recovered till date, interest recovered till date, loan status. Lordship has found.
Which side?
My lord, kindly
Yes,
sees,
yes, yes.
kindly sees this.
Yes, I have now.
My lord, kindly sees principal recovered till date.
Loan status closed.
Closed. So, my lord, on 9/7/2025, it shows closed. Then where is the question of NPA? When I say this, the court is not listening to me. The court does not say anything, and he, my lord, extends it, and my lord takes over my property, and my lord puts it for sale. My lord, I am seeking, my lord, this direction for a stay on that order, because, my lord, otherwise this is, my lord, as they say, Jojjar Muluktar, my lord. I can't do anything because I am a litigant. He has to, my lord, fulfill. From December, I've been crying out that this proceeding is without jurisdiction. He will not give me a chance of hearing. And, my lord, they will go these, my lord, repeatedly, my lord, activities which are contrary to the law. Seize my property when there shows that there is no self shows closed. And, my lord, on first, they have put, my lord, it's a extreme embarrassment, my lord. They'll put it on paper publication for sale of my property. On first, and that's, my lord, I have enclosed the document also. Kindly comes to page 113, my lord. All right, at the bottom, my lord, of last paragraph, pursuant to the same, bank has decided to publish the first public notice for sale of the said property in the newspapers, the Telegraph and Anando Bajar, mostly read by all people, my lord, on 1st of August 2025. All relevant particulars with regard to e-auction, date of time of auction, reserve price are fully provided. Now, Lordship kindly turns the page 14, and they have also fixed the date for auction 3/9/2025. At the top right hand side, my lord, kindly sees date and time of e-auction 3/9/2025. But firstly, my lord, I am on the 1st of August, because of which I have mentioned the matter before my lord, because there is extreme urgency. Otherwise, my lord, this is complete illegally, my lord, they are going against me without even looking into their records itself. The initiation itself, my lord, is, my lord, without jurisdiction.
Yes.
So the very first point which.
Anything more?
My lord, the order impugned is an appealable order under section 18, my lord. And this civil revision should not be entertained under 227 because the law itself is clear under section 18. Any order, whether it's final order or any interim order, any order is appealable, my lord. And I am also supported with the judgment of the Honorable Apex Court that no application under Article 226 or 227 be entertained in the event the order of DRT is under challenge, my lord.
PHR invent.
Yes. Sure. I'll give.
No, there is a subsequent judgment. PHR invent, I think, is in 2024.
Your Lordship, this is case reader of 2023, my lord. Para 26.
Subsequent judgment of 2024
I could not.
considers the exceptions on which the 226, 227 can be filed in one paragraph. Next paragraph says, in a case of SARFAESI, should not be entered.
But there are exceptions carved out.
Exceptions after that, exceptions recorded. First paragraph, next paragraph says, in these banking financial matters, when there is a specific remedies provided, court should not.
But in this case, my lord, I am saying, my lord, it is beyond jurisdiction.
There is no case made out, my lord, because even if the...
I did not want to rely on...
Because Mr. Banerjee, those are the exceptions. Failure of natural justice, and it's expressly without jurisdiction.
This is a case.
So, have you, where is the PHR invent 2024?
I did not bring PHI invent today, but I got the...
That decision considers the exceptions, thereafter says no.
No, there is another decision which considers exception and thereafter in the facts of the case says no, my lord. But in PHI, my lord, that's the facts of the case are different. Here, my lord,
you got that. Have you got
but
that?
the other one I have got.
Because it says no since it's an specific.
But here I have 2024 6 SCC, my lord,
PHR.
Yes. But in the facts of this case, kindly sees the facts of this case, my lord.
Yes, you have marked, your junior has marked. Paragraph 37.
He has marked, he has marked.
And paragraph 38, 39.
Yes, my lord. So is Jai Singh also, my lord. It carves out the exceptions and there goes Jai Singh.
Even though these exceptions, it says here, cannot be done.
Because, my lord, that is, my lord, something.
We are followed in the division bench.
Yes, correct, my lord. Correct. My lord, because kindly sees the facts of the case.
Yes, yes.
Kindly sees the facts of the case. This is a case, my lord, where, my lord, there is no jurisdictional error. Kindly sees Jai Singh also. Jai Singh also says the same thing. Carves out the exception, then, my lord, in that matter dismisses. Saying that, my lord, it is
38 of PHR, Mr. Bank.
I have seen, my lord. Kindly sees, my lord.
Please read it loudly. That is after 37, calls out those exceptions, paragraph 38.
But kindly sees, it is however been clarified that the High Court will not entertain a petition under Article 226 of the Constitution even effective alternative remedies available to the aggrieved person or the statute under which the action is complained of, this is very important, where I, my lord, strike apart,
Yes.
or complained of, has taken itself, contains a mechanism for redressal of grievance.
The SARFAESI Act contains a mechanism for that.
Yes, but I do not in the SARFAESI. My lord kindly considers.
Mr. Banerjee, that point can be taken before the appellate tribunal.
I am not even saying so. My lord kindly directs, my lord, him to hear out my application pending from December.
Tribunal is functioning, my lord.
And my lord will not allow him to put it for sale on first.
Application for that, it did not have jurisdiction. That can be.
Yes.
That has to be decided. I'm directing the tribunal to
Yes.
that application.
He can, my lord, not give me a hearing and go on, my lord, publishing, my lord, this advertisement on first.
What is that application?
My lord, that's the main essay. 1054. Paragraph R and my lord, Q.
Lordship, only two submission I would make, my lord. The DRAT is all.
Tomorrow I'm keeping it as for orders because I have to rise.
But kindly, my lord, passes this order that he hears me within a time frame, and my lord, first he should not proceed with, my lord, the publication.
That I am objecting.
No,
to,
that he cannot. Otherwise,
all-
my application becomes infructuous.
Rightly or wrongly, DRT has passed an order.
No.
That has to be challenged before DRT.
Mr. Banerjee. Now 4:30 is done.